The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I'd like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 8227, the Speak Out Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 8227, to limit the judicial enforceability of...
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 8227, the Speak Out Act, empowers survivors of sexual misconduct by ensuring that they are not subject to non-disclosure and non-disparagement clauses unless they agree to them after a dispute arises. Non-disclosure and non-disparagement clauses are often buried in the fine print of routine contracts that workers and consumers sign as a condition of employment or for goods and services. These are not the sorts of contracts entered into by parties of equal bargaining power. They are contracts of adhesion, forced upon someone who simply wants a job or wants to buy a run-of-the-mill consumer product. And these confidentiality clauses, which most people do not even know they are agreeing to, have contributed to the culture of silence in cases involving sexual misconduct, enabling sexual predators to evade accountability by silencing survivors through intimidation. In many cases, survivors are terrified to tell their stories due to fear that they will be retaliated against or worse. For example, former Hollywood producer Harvey Weinstein, currently serving a 23-year sentence for criminal sexual acts and rape, relied heavily on NDAs to allow his decades of predatory behavior in the film industry to go unchecked. Employment contracts at the Weinstein Company included strict NDAs, which prevented survivors from coming forward with their stories. Combined with aggressive clauses and settlements with the women he assaulted that, according to one of his former assistants, prevented employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, Mr. Weinstein was allowed to abuse dozens, if not hundreds of women before he was finally brought to justice. The confidential nature of these clauses makes it extremely difficult to fully diagnose the scope of this problem. However, it is estimated that more than 1/3 of workers in the United States are required to sign a non-disclosure agreement in their employment contracts. This is particularly concerning due to the rampant nature of sexual abuse in the workplace. An estimated 81% of women and 43% of men will experience sexual harassment in their lifetimes, and 54% of women report being subjected to unwanted sexual activity while in the workplace. These numbers are appalling, but they do not tell the full story. We know that there is significantly more abuse that occurs that is simply never reported. Today, we will take an important step towards fixing this problem by banning the enforcement of pre-dispute, non-disclosure, non-disparagement clauses in cases involving sexual harassment and assault. This legislation continues the committee's important work to protect the rights of survivors to come forward and hold perpetrators accountable for abuse. Last year, in a hearing that none of us will forget, the committee heard from 4 survivors of horrific workplace sexual harassment and assault who had their right to a jury trial taken away by forced arbitration clauses buried in their employment contracts. As they explained, after enduring horrific abuse at the hands of their perpetrators, they had to experience further trauma when they sought to hold their assailants accountable in court and found that they were forced into an arbitration process that was stacked against them. Their arbitration clauses were also combined with confidentiality clauses that prevented them and other survivors from reporting and publicly disclosing their abuse. In response, we enacted the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which gives survivors a choice of whether to resolve their disputes in court or through arbitration. This legislation passed the House with a strong bipartisan vote of 335 to 97 and passed the Senate unanimously. It was an example of how Congress can and should function. We worked together across the aisle to identify a problem, establish a bipartisan solution to that problem, and pass legislation to restore the rights of millions of Americans to their day in court. H.R. 8227 is an opportunity to work together again in a bipartisan fashion to end the shameful culture of silence for cases involving sexual misconduct, promote transparency and accountability, and make the workplace safer for everyone. This legislation is supported by a broad coalition of public interest organizations, including the American Association for Justice, the National Alliance to End Sexual Violence, Ralliance, the Army of Survivors, the National Domestic Violence Hotline, and the National Coalition Against Sexual Assault. I thank my colleagues, Representatives Frankel, Buck, Cicilline, Jayapal, Griffith, Bustos, and Owens, for their leadership on this issue, and I urge my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill is a misguided approach to solving the problem of confidentiality agreements for victims of sexual assault and harassment. Of course, no one should be subject to harassment or assault. Victims of harassment or assault should be able to get justice. But this legislation is truly a one-size-fits-all approach that is ill-suited to address these issues. The enforceability of confidentiality agreements traditionally falls to the states, so this bill raises important questions of federalism and the proper exercise of federal power. Some states are already legislating on confidentiality or considering whether to restrict how non-disclosure agreements work. In addition, this piece of legislation is not well drafted. For example, though the bill is intended to affect only, quote, pre-dispute agreements, that's not how it applies. As drafted, some post-dispute agreements victims agree to after the dispute may be unenforceable under the legislation. Exactly where the pre-dispute line gets drawn matters as well. If only agreements that follow lawsuits are enforceable, victims may be forced to sue to get the kind of settlement they'd like. It's not clear that going to court is always best for all victims. We heard from very brave women last year in our committee, but not everyone wants to share their experiences publicly. When victims would rather not go public, it seems wrong to force them to bring claims in court to get the kind of settlement that they'd like. There are also serious concerns about the bill's scope. For example, because it applies to claims filed after enactment, it could retroactively upset existing settlements. This is a major problem. I look forward to a robust discussion as we think about what is best for the victims and for the American people, and yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I will now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 8227, offered by Mr. Nadler of New York.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. This amendment makes two minor changes to the bill. It removes the findings section and adds the current year to the bill's short title. Otherwise, it makes no substantive changes to the bill. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purposes, Mr. Cicilline seek recognition?
I move to strike the last word.
The gentleman is recognized.
Mr. Chairman, thank you for holding today's markup of H.R. 8227, the Speak Out Act, which would prevent the enforcement of pre-dispute non-disclosure agreements, or NDAs, in disputes relating to sexual harassment and sexual assault. It is unthinkable that widespread sexual misconduct can be covered up and swept under the rug because of NDAs snuck into take-it-or-leave-it contracts. And it's unconscionable that millions of people fear risking their livelihood for speaking out about their sexual predators. This bill is simple. It will ensure that any survivor who wants to share their story can, and I'm proud to support it as an original co-sponsor. H.R. 8227 does so by prohibiting the enforcement of confidentiality and non-disparagement clauses in everyday contracts which silence survivors before a legal dispute even arises. In doing so, this bipartisan legislation will bring sunlight and transparency. It will make our society more just, and it will help end the culture of silence that allows sexual predators to evade accountability. I'd like to thank my colleagues, Representative Frankel, Buck, Jayapal, Bustos, and Griffith, for their leadership on this issue. Your hard work has brought back the constitutional right of millions of Americans and restored the voices of countless survivors of sexual harassment and assault. This legislation is important, and it's a particularly important complement to H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which we enacted earlier this year. It's another step in our critical work to eliminate the culture of silence that prevents survivors of sexual misconduct from having their voices heard and thereby allows abusers to continue. But I'm a little bit confused and frankly disturbed by the opposition from the ranking member to this legislation. During last year's consideration of H.R. 4445, my colleagues on both sides of the aisle recognized the importance of preventing abusers from hiding behind NDAs and urged the committee to act and help protect survivors from this abusive practice. In fact, when we were considering the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, many of my Republican colleagues and their witnesses discussed or endorsed reforms that are embodied in the bill that we're considering today. Mr. Issa, in a long line of questions for one of our committee's witnesses, was also a survivor of sexual assault, asked repeatedly if it would be an improvement to the status quo if, and I quote, non-disclosures were taken out of the binding arbitration process in the case of assaults, end quote. And when he turned to Ms. Marshall Perry, a Republican witness, she testified that preventing NDAs in cases of sexual assault and harassment would, quote, solve the problem. In a criticism of Representative Bustos' bill on the House floor, Ms. Fishbach pointed out the need for separate action to address the silencing of sexual harassment and assault claims, noting that even outside of forced arbitration, I quote, it is still possible that separate contract provisions could be used to impose confidentiality or keep details about an employer under wraps, end quote. And Ranking Member Jordan also asked Ms. Marshall Perry whether we can fix arbitration by, quote, getting rid of or dealing with non-disclosure, confidentiality, end quote. And after she made it clear that she did believe that confidentiality clauses and NDAs are, quote, precisely the problem that we're dealing with, end quote, Mr. Jordan responded, and I quote him here, yup. Later on the House floor, Mr. Jordan made it clear he supports the goals of this legislation by saying, and I quote, victims of sexual assault and sexual harassment must always have their claims heard. They must never be silenced or intimidated into silence, end quote. Why then does the ranking member oppose legislation that simply makes sure survivors cannot be silenced before they have a chance to make their experiences public? It's incredibly disappointing that we cannot agree on this committee in a bipartisan way on a bill that simply allows survivors of sexual trauma to tell their stories. I hope that all my colleagues on this committee will remember what they said last year and join me in voting for this common sense, necessary legislation. And I thank you again, Mr. Chairman, for your leadership. I thank my colleagues for being in the hearing room today, and I yield back.
Gentleman yields back. For our purposes, Mr. Buck seek recognition.
I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Buck of Colorado.
Amendment will be considered as read, and the gentleman will have 5 minutes to explain his amendment.
It won't take me nearly that long, Mr. Chair. It is a very short amendment, and all it does is make sure that we are protecting trade secrets and proprietary information. And really, I think it's self-explanatory and doesn't require any further explanation. So I hope my friend withdraws his objection to this very straightforward motion or amendment. And I yield back.
Does the gentleman insist on his point of order?
I withdraw my point of order, Mr.
Point of order is withdrawn. I recognize myself in support of the amendment. I support the amendment of my colleague from Colorado, Subcommittee Ranking Member Buck, which would simply clarify that nothing in the bill would prevent companies from protecting their trade secrets through non-disclosure agreements. Doing so is consistent with the original purpose of these clauses, to protect complex and valuable trade secrets, and does not weaken the application of the bill or unduly narrow its scope. I thank the gentleman for offering the amendment, and I urge my colleagues to vote yes. Is there any further discussion on the amendment? For what purpose does the gentlelady seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I, too, rise in support of this amendment. The NDAs were originally intended to be used as a way for companies to protect trade secrets and proprietary information, not to cover up sexual abuse. However, their expansive use now is putting all Americans at risk by keeping secret predatory behavior and allowing it to flourish. So while this is a very well-intended and appropriate amendment, I rise in support of the underlying bill. It is well past time for Congress to end the abusive practice of silencing victims. NDAs make it possible for companies to silence survivors while allowing predators of abuse to continue abusing. Allowing survivors to speak if they so choose will end the perpetuation of abuse. The bill does not invalidate any contract, but rather only enjoins the judicial enforceability of a certain provision within a contract in the event that a survivor wants to speak freely about what happened to him or her. The bill preserves state laws, protects the state's rights to pass different or broader laws as fitting, and it only applies to pre-dispute, giving survivors the choice to enter into NDAs as part of a settlement agreement if they wish to retain that right. In recent years, a slew of media reports exposed sexual assault and harassment among some of the country's most powerful companies and men, including Hollywood mogul Harvey Weinstein, Bill Cosby, Fox CEO Roger Ailes, Bill O'Reilly, R. Kelly, the list goes on, who used NDAs and confidential settlements to cover up sexual assault. We want women, survivors of sexual assault and harassment, to have the right to speak out, to tell their stories, most importantly, because they want to work and be free of sexual assault and harassment, not to allow perpetrators to perpetuate their ambitions while others lose their careers, lose their peace of mind, and worse. I rise in support of the amendment. More importantly, I rise in support of the bill, and I yield back.
Gentlelady yields back. Who else seeks recognition? For what purposes Mr. Gates seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And I have some concerns about this legislation, really because I think our committee did so much important work to create an appropriate venue and forum to resolve these disputes by getting rid of arbitration in these circumstances. And I was proud to join the majority in a multi-year effort to ensure that that got done and that reform was signed into law. But just as Mr. Cicilline pointed out, well, all the Republicans who opposed the arbitration changes said what we really need is NDA, non-disclosure agreement changes. I think one could reasonably say that the changes we made to the arbitration process absolve the need for these changes because there now is a place where you're not in some silent, constrained, I would say rigged environment for the powerful against the weak. People now have the choice. So if someone is being silenced, they're no longer being silenced because a powerful company or a powerful person got them to surrender away their right to an Article 3 resolution of their dispute in advance of that dispute even arising. They're being silenced by virtue of their own decision. And, you know, what is the value of your silence if you don't have the agency and power to sell it if you so choose? And so I think that empowering people that have been through any type of awful circumstance like the proponents of the bill describe would suggest that our Article 3 courts are now available. That is an appropriate forum. Also,
the gentleman?
Yeah, no, I'm eager to get into a colloquy, but on a specific point that I've been thinking a lot about. So we used to not have no-fault divorce in America, and that required people who sought a divorce to plead a basis for that. And so even if there wasn't infidelity or abuse in a marriage, someone who wanted to escape that marriage would be required to plead those things. Otherwise, the dissolution of marriage would be automatically dismissed on the pleadings. Here, what I worry about is that let's assume there's some feature of your employment that you want to be able to whistleblow on, a larceny, an embezzlement of some kind. Well, if you would otherwise be constrained based on a non-disclosure agreement, but if you can somehow bootstrap other claims to a sexual harassment claim, and you can say that sexual harassment was sort of part of whatever nefarious activity you wanted to report, you could actually draw false claims of sexual harassment just for the virtue of being able to evade a non-disclosure agreement. So I'd ask the gentleman from Rhode Island if that concerns you.
Yeah, I thank you. First, I want to say thank you for your support of the prior legislation that this committee passed and the president has signed. I think it will make a tremendous difference in the lives of so many victims of sexual assault and harassment. The only thing I wanted to raise with you, and I understand your concern, is there's a whole range of activities that might occur, or that does occur in this space, but that doesn't result in litigation. It's good news now that it can't be forced into arbitration, that people have a right to go to court. But there are a number of victims, unfortunately, of this kind of activity who say, I want to be able to share my story so that other people know to be careful. Other people know, don't go work for that person, don't go work for that company. I don't intend to go to court and sue because I choose not to do that, but I want to be able to speak honestly and openly about what happened to me. This bill will ensure that they get to do that. And so I think everything doesn't result in a lawsuit. We've solved people who go to court and can no longer be forced into arbitration, and that's great. But we also want to make sure this secrecy that cloaks this activity that allows perpetrators to continue because nobody knows about it, to remove that. So I think that's why they complement each other, and they're both important. And I thank the gentleman for yielding.
Would the gentleman yield?
Certainly, Mr. Chairman.
I just think the gentleman misspoke. We used to have fault divorce, now we have no
I'm
fault
sorry.
divorce,
Yes.
not the other way around.
Yes, I'm not proficient in divorce, fortunately, but yes.
That's good. We shouldn't have
appreciate-
too many divorces.
I appreciate the correction. To the gentleman from Rhode Island, I appreciate that, but I don't know that reduces the likelihood of this legislation incentivizing false allegations, right? Both things can be true, that you need to create a non-litigation forum, but at the same time, if you have to allege sexual harassment in order to evade an NDA, and you want to evade the NDA for some reason that has nothing to do with sexual harassment, I worry that still would, it just creates this bizarre incentive to allow people out of that. And I know that this... Sure.
Your concern is that if you prevent an NDA from being enforced, that it's going to cause people to make up an event that didn't occur? I mean, I just don't think there's any evidence.
But a lot of people, when we only had fault divorce and not no fault divorce, people made up infidelity or abuse because that was the only way they could get the divorce.
But the point is, if someone makes a false claim, there are a number of mechanisms to make them responsible for any harm that comes from making a false claim. That exists in the law already.
I agree. I just worry that this sort of goads that a bit. And I
guess I would say on balance, I worry less about that and more about victims of sexual harassment and violence being able to honestly disclose so we can prevent further harm to more victims.
And I think what this...
The time
I know
of the
I'm
gentleman,
out of time,
the time of the gentleman has expired. For what purpose does the gentlelady from Texas seek recognition?
To strike the last word.
Gentlelady is recognized.
Let me acknowledge sponsors of this bill. Mr. Chairman, thank you. I moved to focus on certain points. I appreciate Mr. Gates' commentary because he's right. He was for the bill and advocated earlier on this legislation. Let me try to craft this in a way that hopefully will be effective in his reasoning. But first of all, let me acknowledge sponsors of this legislation, Congresswoman Frankel and Congressman Bustos. Congresswoman Frankel chairing the Democratic Women's Caucus. It's a very important statement. And to Mr. Gates, I think you view this as creating havoc. And I would argue that would not be the case. The issue is the pain of silence and what happens to someone who is victimized and has to be silenced. I would argue that is more the point than the breach of an NDA. It might be a situation where someone has to give this answer to something that is necessary in their life, a new job, some applications for a variety of things. Silence is punitive. It is punishment. And in some instances, it gives more freedom to the very perpetrators that you joined us and suggested that they should not be empowered. It gives them more power if this person continues in the workplace, for example, to continue harassing and maybe even assaulting women that are around them. Ending this would at least allow the person to be contained. It may never have to be utilized. Someone may never have to speak about it, but it can be a basis for ending this cycle of abuse. And then to be jeopardized as someone who's already been abused, to be sued by companies for breaking an NDA, the threat of legal retaliation that for a person who's already gone through the trauma of that, the costs that will come about for defending yourself and that you didn't intend to breach it, and the fact that NDAs are everyday occurrences. They're not something unusual. That means that you have the opportunity as a junior level secretary breaching an NDA without purposefulness, be subject to lawsuit, be subject to expenditures, and frankly, be in a quagmire that you don't deserve to be in. So NDAs are in settlements, they're in everywhere. Just view this as a protection that may never be used. But it is a protection necessary, I believe, not to be threatening on the part of the victim or to use it on the part of the victim, but in instances, the big person in this NDA is that large corporation. That's the entity that is a difficult obstacle to overcome. Over 1/3 of the U.S. workforce is bound by an NDA, according to Harvard Business Report. But instead of just protecting the company from the release of damaging information, these NDAs work to protect power dynamics that have the effect of enabling abuses. So 1 in 3 women have faced sexual harassment in the workplace during their career. An estimated 87 to 97% of those experiencing sexual harassment never file a formal complaint. So these women have no voice because the system rewards those who may be their boss, their colleague, and it is a frightening reality. This legislation, the name seems to cause an activation, but what it does is suggest that you don't imprison the victim again twice. You allow them to be free when the circumstances comes, and you contain the manipulator, the harasser, the abuser, and you make a better workplace. So I ask my colleagues, I hope, Mr. Gates, because you have been supportive, I'd ask that you support this, be reminded of the mental health status of the victim as well, and people have to continue working. They have to work, provide for their families. So I ask my colleagues to support this legislation, and I support the underlying amendment. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purposes does the gentleman from Ohio seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. I yield to the gentleman from Colorado, Mr. Buck.
I thank the gentleman for yielding, and I just want to, my friend, the ranking member, made a point, and my friend from Florida, Mr. Gates, made a similar point about why do we need this if we have, and I'm going to use a woman as an example because I think the majority of sexual assaults and sexual harassment cases in the workplace involve women. If a woman has the right to go to court or go to arbitration, why do we need this? And I think it's, one reason is, and I'm going to give a hypothetical, if someone is harassed or assaulted in the workplace, that individual may not want to go to court, may not want to publicize. They may have a career that would be jeopardized, and they have made the decision that they don't want to jeopardize their career for the sake of exposing this publicly. But they do want to tell their coworkers, or they do want to tell people that are considering working for this company, or they do want to talk in a way in the community that would help protect others from this predator about the conduct that's going on. If it is a false statement, then there are remedies in the law to deal with the false statement. If it is a true statement, then the predator is somewhat isolated. The company is forced to deal with the issue, and this victim, survivor, has made a rational choice based on her needs, her future desires, her dreams, and the horrifying reality that she has to deal with. So I think that there's an assumption that every rape victim, every harassment victim needs to go to court in order to tell their story. I don't think a lot of people want to do that. And while as a prosecutor,
Gentleman yield. I just want to point out that the bill does not force anybody to go to court. It simply gives them the option.
and that's my point. That's my point, Mr. Chairman, that this
That's
bill.
what the bill does.
Right. Yeah, we're agreeing. What I'm saying is that the argument against this is that that a victim already has the ability to tell their story if they go to court.
Will you yield?
And I will.
So,
Can I just finish my statement and then I'll yield? I'm sorry. I'll yield.
So here's my question for the proponents of the legislation. Do the proponents of the legislation believe that the victim of sexual harassment should be allowed to sell their silence? Because one argument would be, you know what, they shouldn't be allowed to, because if they sell their silence, then maybe someone else is victimized later. But one theory of the case might be, who are we to tell someone through the force of law that they don't have the ability to sell their silence through an NDA? I'm just curious which side the proponents fall on.
Well, I'll tell you, reclaiming my time, or reclaiming the gentleman's time from Ohio, I believe, and I wouldn't use the term selling silence. I think it's, I think that if a lawsuit is brought or if there's an arbitration involving this issue, then I do think that a victim has the ability to enter into a non-disclosure agreement in that situation and benefit from a settlement. And that's exactly what this legislation anticipates. And I have another amendment that I will offer in a moment that clarifies that further. But I don't think that someone sells their silence before the rape or sexual harassment occurs. That's my concern. Someone that enters into a contract not knowing that there are predators in the workplace, oftentimes right out of college, they enter into it. It is a contract of adhesion. They are not offered an opportunity to negotiate something like that.
So quick follow-up. So as I understand that, you believe that someone should be able to sell their silence post a harassment event, but they shouldn't be able to sell it pre that event. What's your response to the ranking member's concern that the legislation as drafted would impact NDAs pre and post dispute?
If the gentleman will yield, I'm happy. There's nothing in the legislation that prevents settlement. What the legislation does is it empowers the survivor of that sexual abuse to make that determination. They either are going to disclose it and sell it or not. So this simply takes away from the perpetrator the power to silence the victim.
I'm going to reclaim my time from everybody and just ask that we get back to the amendment that's at issue, if we can, and then I'm going to yield to the gentleman from Ohio.
I yield back. My time's expired.
The gentleman yields back. For what purpose does Ms. Ross seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. And I want to thank Mr. Buck for his amendment, which I support because it does not go to the heart of this bill, but it makes it clear that if there are situations that involve trade secrets or some other kind of proprietary information, that information is kept confidential. But Mr. Buck is 100% correct. These NDAs, pre-litigation, pre-dispute, are contracts of adhesion. They are power and control of businesses and corporations that don't want to accept liability for what their employees might do to each other. They also create a disincentive to have a strong, robust HR department, to review people's conduct, and to create an environment where people can do their best work. This bill is common sense. It just says we cannot have people signing away their rights to have a good workplace as a condition of employment. That isn't buying somebody's silence, as Mr. Gates is talking about. That is signing away your ability to have a decent work environment and protecting an employer who doesn't care about that work environment and has no incentive to improve it. This is a great bill. It is a bipartisan bill. I support the bill, and I also support the amendment that we're supposed to be debating right now. Thank you, and I yield back.
Gentlelady yields back. Who seeks recognition? What purposes Mr. Bishop seek recognition?
To speak on the amendment.
Gentleman is recognized.
There is an odd lack of symmetry in the conversation. Mr. Buck just said that if someone speaks falsely to destroy the reputation of a coworker or a supervisor, then there's recourse in the law available to the supervisor or the coworker whose reputation has been destroyed. I would say that recourse is imperfect from having dealt with it for 30 years. And often the question at the end is, where do I go to get my reputation back, even if I'm successful? But the recourse that you're content to leave that person to is the court, to go with the defamation claim in civil court. I, too, I voted for the provision to change arbitration law so that sexual harassment, sexual assault disputes cannot be made arbitrable mandatorily by an agreement ahead of the dispute. But this is a whole different animal. In this situation, you have someone who's been the genuine victim of a sexual assault or harassment can always file charges with the EEOC, always could, even if there was an agreement not to speak. Now they are not prohibited from going to civil litigation by virtue of a mandatory arbitration clause. They can go to civil court. They can always make a criminal complaint. That's always possible. The justice system is available in full now with the bill that was passed with bipartisan support concerning arbitrations. But this one eliminates from consideration the innocent person accused, the person who has a sterling reputation, who someone sets out to destroy. I can't think of a great example off the top of my head, but think of somebody like Jussie Smollett making an accusation. People do act, people do speak out with malign motives. Where is the symmetry in saying, well, that person can be left to the judicial system, but not the victim, not the alleged victim of a sexual harassment? There's endless rhetoric in the last several weeks about rights. But what we're talking about is stripping the rights from American people to decide to enter into a contract about what they will and will not make public. It's interesting, the chairman began by offering as the example Harvey Weinstein. I would suggest the problem with the Harvey Weinstein situation was not that victims were bound to non-competes or were bound to non-disclosure agreements. The problem was that liberals made him a giant. While he poisoned the culture, they thought he could do no wrong. Democrats lined up endlessly to kiss his ring. That was the problem with Harvey Weinstein, and Harvey Weinstein is an example of the reason that we need to strip the basic power to contract from every employee and every boss in every small business across the country. Holy cow. In the arbitration context, there was also this. The United States Congress had entered the field with the Federal Arbitration Act. We made an adjustment to the Federal Arbitration Act to put off limits from that disputes in the nature of sexual harassment, sexual assault. This is also a different animal from that. The Congress would be assuming from the state governments immense power over contract law. States can do this if they choose to, one by one. It would be perfectly appropriate if they choose to make those decisions to their contract law. But for the federal government to enter this area anew, take all that power not only from the American people to decide what contracts to enter into, but take also the power of contract law from the states, is a breathtaking overreach. I say again, I understand how folks regard the subject of sexual harassment, and it's been a pervasive problem. That's why we make tools available like the Civil Rights Act of 1964, Title VII, the charging process, ample litigation opportunities. But this is utterly unbalanced, and no Republican should support it at all. I yield back.
The gentleman yields back. For what purposes? Gentleman from California seek recognition. Gentleman is recognized.
Thank our colleagues for this healthy debate on this amendment and on this bill. Listening to my colleagues talk about contract rights, I would say, what's a public policy here we're looking at? We're looking at essentially protecting future victims, preventing future sex crimes. Shall we allow victims to be silenced by a few dollars and therefore put future victims in harm's way? When I was in the state legislature, I did a lot of work on DNA, sex crimes, statute of limitations, and what I learned was the average sexual predator attacks, hurts 8 to 10 times before that person is actually caught. So assuming statistics hold, these predators, once they're caught, already have a history of attacking individuals. You put a gag clause on these victims, and these individuals are going to continue to attack. So you got to balance public policy, contract law versus protecting women and men, children from future victimizations. In my district right now, without being specific because of a gag order, I know an individual that entered into a gag clause with a number of victims. He threatened, he cut a deal. These individuals cannot speak about their sexual offenses. This individual recently got another job in what I would call a target-rich environment. I can speculate, but I cannot talk about his crimes because there's a gag clause, a contract that says you may not speak about this. And this is what we're talking about today. Protection in the workplace, protection in public from known sexual predators. So that's the decision we're making today. Do you protect future victims from known predators, or do you uphold contract law? Thank you, Mr. Chair. I yield.
The gentleman yields back. Does anyone else seek recognition? If not, the question occurs, for what purposes Mr. Roy seek recognition?
I would just seek a clarification from the bill sponsors that it is my understanding that the legislation is not limited to enterprises that cross state lines, corporations that have locations in multiple states. That, for example, a business that were solely in the Commonwealth of Virginia or the state of Texas or state of California with a contract between that business or enterprise and the individual employee, that would be limited, this bill would apply to that situation, a non-interstate enterprise. Is that correct? Is that my understanding? I would just be asking any of the bill sponsors.
If the gentleman will yield,
Yeah, sure.
if you're asking, this act does not supersede any state law in this space. There's not a, it's on page 2, the top of page 2.
That's not quite accurate.
Reclaiming my time, and I might yield to the gentleman from Texas 1 second. I think, just to be clear though, not superseding state law. I mean, the fact is though, the bill and its primary provision applies, by my reading, with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure clause or pre-dispute non-disparagement clause shall be judicially enforceable in instances in which conduct is alleged to have violated federal, tribal, or state law. Meaning this is not just applying to, say, McDonald's or a massive interstate corporation. It would also be applying to any business wholly and fully located within the state of Texas that employs an employee wholly and fully located in the state of Texas with an agreement with that enterprise, which raises to me, I think, serious constitutional questions under Lopez, Morrison, Raich, Dissent, and all the various sort of progeny, in my observation. I would yield to the gentleman from Texas.
Thank the gentleman. Actually, what the law says that's being proposed here is this act shall not be construed to supersede a provision of state law. If that's all it said, it would be okay. But it says that establishes, implements, or continues in effect a requirement or prohibition. In other words, if you do exactly like we say you must do in state law, this won't supersede it. But when it says in the last provision, this act shall apply with respect to a claim that is filed under federal, state, or tribal law on or after the date of the enactment of the act, it makes clear this bill, this committee, sometimes we get a little arrogant, we're saying it will apply to every state litigation that involves this process.
Right.
And and if you have a law, just like we've put here, then we won't supersede that law if it's just like we have.
Right.
But otherwise, we're stripping the states of the power to create laws. And so I have an amendment to deal with that, but that is the answer to the gentleman's question.
Well, I'd be taking my time back, and I appreciate the gentleman from Texas.
Mr. Gentleman, I don't
yield
think
for
that's
the-
correct. If you look at the amendment in the nature of a substitute, continued applicability of state law, this act shall not be construed to supersede a provision of state law that establishes, implements, or continues in effect a requirement or prohibition except to the extent that such requirement or prohibition prevents the application of this act.
Want to yield? Do you want? I'll yield to the gentleman from North Carolina.
I think Mr. Cicilline's point is, when I first read that language, I'll tell you, I kind of just made a note to come back to it, but what it begs the question is, what is a requirement or prohibition? So if it doesn't supersede a provision of state law that establishes, implements, or continues in effect a requirement or prohibition, I mean, that's sort of an open-ended phrase. It doesn't say, but I think what it means is a requirement or a prohibition relating to these types of contracts. That is to say, a non-discrimination agreement on a sexual dispute point. So so the law as a whole sets a floor. You can't enforce any non-disclosure agreement concerning a sexual assault or harassment dispute. But if a state's done somehow more or done it itself, then this doesn't literally have any effect.
Reclaim it. Go ahead. I'm reclaiming my time. I'll close out my time. I'm sure we
Would the
can
gentleman
engage
yield?
in-
Would the gentleman yield?
Well, I think I've just got 30 seconds left.
I think the gentleman.
I'm going to reclaim my time for the last 30 seconds, and we can engage in colloquy further. I agree and associate myself with the remarks from the gentleman from North Carolina, and I would stipulate further my concern about my original point, which is a slightly different version of that point, which is to the extent we even want to go down this road, we're not going down the narrow road of clearly applying it to corporations that across state lines. We're saying any business, and any business that is fully operating within the
Would the
bounds of the
gentleman now
state
yield?
and the employees that work for that. And now I have no time left to yield back.
I'll extend the time for 2 sentences. I entirely agree with the gentleman. He's exactly right in his reading of the bill, and the bill establishes the public policy of the United States that NDAs are contracts of adhesion, whether it's under state or federal law, and should be banned entirely, and that's the purpose of the bill. And I'll yield back.
And I just add that to the record for the Supreme Court when the litigation occurs. I appreciate the chairman.
Who else seeks recognition? If no one else seeks recognition, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. The amendment is approved. Are there any further amendments to the amendment nature of a substitute? For our purposes, Mr. Buck seeks recognition. Mr. Buck has another amendment.
Mr. Chairman, I reserve a point of order.
A point of order is reserved. The clerk will report the amendment.
Amendment to the amendment and the nature of a substitute to H.R. 8227, offered by Mr. Buck of Colorado.
Without objection, the amendment will be considered as read. The gentleman has 5 minutes to explain his amendment.
I thank the chair. Like my first amendment, Mr. Chairman, this is a clarifying amendment. We've heard concerns, particularly in the ranking member's opening statement, but from others also, that this bill could impact the ability of parties to enter into post-dispute NDAs. While I don't believe the bill as drafted would pose that problem in any way, I want to make it abundantly clear that post-dispute NDAs are not covered by this bill. My amendment also includes a clause to ensure nothing in the bill limits states' ability to legislate regarding post-dispute NDA provisions. And I, at this point, would recognize the gentleman from Rhode Island if he wants to enter into a call.
Yes, I thank the gentleman. I appreciate the concerns of my colleague. To be clear, the bill only prohibits the use of NDAs before a dispute arises, which is triggered by the filing of a lawsuit under a state, federal, or tribal law. Nothing in the bill prevents parties from voluntarily agreeing to a settlement that does not include an NDA. In other words, this bill is carefully tailored to prevent sexual predators who are rich and powerful from evading scrutiny for their misconduct by buying the silence of survivors. And this concern, as you know, is not theoretical. Harvey Weinstein paid the survivors of his horrific abuse hundreds of thousands of dollars to silence them. His settlements included strict NDAs that prevented survivors from making their experience public. These clauses were drawn broadly, preventing employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, according to one of Mr. Weinstein's former associates. During our hearing, Tatiana Spotswood testified that her abuser, former Affinity CEO Zia Chisti, used confidentiality clauses in her employment contract to keep multiple instances of overt sexual harassment and violent assault hidden while Ms. Spotswood's allegations were arbitrated. She testified that as the CEO of the company, he had power over my life and career, and I was anxious not to insult him or make him mad. And while she received a settlement in arbitration, his lawyers offered to give her father $1 million in addition to her arbitration award to prevent the case from becoming public. She was only able to come before the Judiciary Committee about her employer's abusive behavior and make her story public after receiving a congressional subpoena compelling her testimony. So those are two clear recent examples that strongly caution against preventing survivors from coming forward before a lawsuit is filed. Having said that, if the gentleman is willing to withdraw his amendment, we will continue to work in a bipartisan way after the markup to address his underlying concern before the bill comes to the floor.
I thank the gentleman, and I reclaim my time. At this point, I'm not going to withdraw. I will allow hopefully more debate on this issue, and if we can strengthen this amendment in some way, I'd like to see that, and then I will consider withdrawing at that point. So I yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
I do.
For what purpose does Mr. Gates seek recognition?
Move to strike last word.
Gentleman is recognized.
So there's a fundamental misunderstanding about the operation of the bill and the operation of the amendment. Mr. Jordan took the position that the bill bars certain pre-dispute non-disclosure agreements. And Mr. Cicilline just said that the bill does not do that. And the misunderstanding comes with when a dispute arises, that can occur before a lawsuit is filed. I've litigated a number of these cases in private practice, and it is a fiction to say that the dispute arises at the time that somebody goes down to the courthouse and files a pleading. That has never been the case in any one of these matters that I was involved in litigating, and in almost every circumstance I'm even aware of, there are pre-litigation demands. And what the legislation does currently, and majority staff agrees with this, the sponsors of the bill agree with this, that currently the way the bill is drafted, you are robbing victims the ability to enter into a non-disclosure agreement post-dispute, but pre the filing of a lawsuit. That is, we should all agree to that. That is what the effect of the bill is. Now, the reason the Buck Amendment, I think, resolves a lot of those concerns is that it clarifies that your dispute can occur, the event of harassment can occur, and that you still have the full complement of rights after this bill would become law that you do today to enter into a non-disclosure agreement. I can't imagine the sponsor of this bill would want to go from a circumstance where today there's a window of time in this horrific series of events where someone could enter into a non-disclosure agreement and that we're taking that away from people. I don't think that's the case. So I support the Buck Amendment. I think the Buck Amendment would probably get a lot more people to support the underlying bill. And
Mr. Gates, would you just,
sure.
I'm trying to understand what your concern is. So if you have an individual who is a survivor of sexual harassment or sexual assault in the workplace who has not yet filed a claim and there is no NDA agreement, there is nothing in this bill that would, of course, prevent that survivor from settling a potential claim and saying, I will not sue you if you pay me X amount of money, et cetera. So there's that ability of the survivor to decide whether to disclose or not remains with the survivor.
But the ability to enter into a non-disclosure agreement.
Well, it wouldn't
is
be a
robbed
non-disclosure,
from the
it would be a
survivor.
settlement.
But the settlement agreement couldn't involve a non-disclosure agreement that would be operational.
And there is nothing in this legislation that would bar that.
I don't think that's the case, Mr. Cicilline. I think that if you look at the definitions on
There's
page
nothing in this
2,
legislation
section 3,
that
line
has,
13.
but
they
this
talk
is about in the example I just gave you, that's a settlement of a potential claim. There's nothing that would prevent the parties from agreeing not to discuss it once they've reached a settlement.
Mr. Cicilline, active harassment occurs. No lawsuit has been filed, but a demand has been made to resolve the dispute with money in exchange for a non-disclosure agreement. If this bill, in this form, were to become law, that would not be allowed. And I think that's what your colleague is sharing with you now.
Will the gentleman yield for question?
I'll yield to Mr. Goldman.
Yeah, when this says that with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure or pre-dispute non-disparagement clause. So when does the dispute begin?
See,
Does that begin when you actually notify the employer that that employer has sexually harassed you? Or does it begin when the incident? I think this language is much too vague and probably should say something like before the incident giving rise to the dispute, because this is very vague and it's going to cause a lot of heartache.
I think Judge Gomer has rightfully isolated precisely the issue. And in many areas of law, the way we mark the incident is when the facts give rise to a claim, right? When a claim arises from the event. And so I think of when the dispute begins at the time of the offending conduct, not at the time of the filing of the lawsuit. And so, again, I believe there's a high probability that this legislation is going to become law in some form. And so we offer these suggestions, and I think the Buck Amendment is offered so that
The gentleman would yield for one more
achieves
time.
that objective.
Just to be clear, in the bill that is before the committee, that question that Mr. Gomet raised is answered in Section 3. The pre-dispute non-disclosure clause means a provision in a contract agreement agreed to before a lawsuit is filed. So that's the triggering mechanism. I think the problem with the amendment is if it included access to counsel so that the determination is made with consultation with counsel, I would have less concern about the abuse of that process.
I just feel like if we compare this experience to like the arbitration experience, the cake is not baked here. The way I feel like we were a lot further along in understanding.
Which is why I think
legislation.
we can work out Mr. Buck's concern if we have a little more time on this issue before it comes to the floor. But I think we basically agree, and I think it's just a question of sort of fine-tuning the language. And I've had the privilege of working with Mr. Buck on so many issues. I'm confident that we can resolve this one.
We'll try to keep an eye on him over here.
Gentleman's time has expired. Who seeks recognition? If no one else, then the question occurs on the amendment.
Mr. Chairman,
The amendment is withdrawn. Are there any further amendments to the amendment in the nature of a substitute?
Yes, Mr. Chairman, I have an amendment at the desk.
The gentleman will, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Cicilline of Rhode
Without
Island.
objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This is a technical amendment that will insert language used in the definition of pre-dispute non-disclosure clause to Section 3.2, the definition of pre-dispute non-disparagement agreement. All this amendment will do is ensure that non-disparagement clauses, which can prevent survivors from making any negative statements about their abusers or employers, regardless of whether the statement is related to the nature of the dispute, are given the same treatment as NDAs under this law. So this is a technical amendment. I urge my colleagues to support this and yield back the balance of my time.
The gentleman yields back. Is there any discussion of this amendment? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. Are there any further amendments to the... Someone want to talk? I'm sorry, Mr. Gomet. We'll withdraw the vote. Mr. Gomet is recognized.
Yes.
Oh, the amendment is agreed to. For what purpose does Mr. Gomet seek recognition?
He doesn't have one. Have an amendment.
The gentleman has an amendment. The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Gohmert of Texas, page 1.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain the amendment.
Thank you. This does fix a problem that makes this what should be considered unconstitutional. Although there are times I think this committee may be the smartest committee in the country. It's certainly
Point of
not
order,
true all
the
the-
gentleman in the press will note that.
It's certainly not true all of the time, and sometimes maybe it's not a majority of the time. But we cannot disregard the federal Constitution and this bill, and I'll vote for it if we can make an amendment to fix the problem here, and that's what my amendment does. Instead of saying in which conduct is alleged to have violated federal, tribal, or state law, we've got no right as the federal government to step into state law and say, look, we're not even going to talk about a nexus to federal authority. We're just going to jump in and say, all your state laws and state lawsuits over this area, we're superseding them. Unless, of course, as it says in the next paragraph, unless, of course, you have a provision that's just what we dictated or more stringent. That's not our right. In state disputes involving state law, it's up to the states, and we should not step in and, well, it's overstep in and exceed our authority. This needs to be a good law that's not overturned down the road, that so that litigants that have been through the horrors of sexual harassment, sexual assault, don't find out that their lawsuit got overturned because this committee took authority it didn't have in state lawsuits. So if we can back up and say, look, this will only apply to conduct alleged to have violated federal or tribal law, then we're clearly within our authority. It will never be reversed on that basis that it violates the Constitution, usurps authority we don't have, and then once we make it clear, and actually I noticed under B part, it probably should say this act shall not be construed to supersede a provision of state law regarding claims under state law. But nonetheless, we have got to make clear this is not an overreach by the Federal Judiciary Committee. This is doing what we have authority to do under the Constitution. That's all my amendment does. And if the amendment is passed and accepted, I'll be able to vote for the bill. I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. The amendment seeks to strike out the application of the bill to state law. The whole point of the bill is to preempt state law in this matter and to have a uniform law across the federal government. It's the same as the Federal Arbitration Act, which under the Interstate Commerce Clause has been upheld repeatedly, and there's no doubt that the federal government has the ability under the Interstate Commerce Clause of the Constitution to enact this law and to preempt state law, as has been repeatedly determined by the Supreme Court, for example, in upholding the Federal Arbitration Act numerous times. And this only applies, of course, if there's a direct conflict between this law and federal law and state law. I yield back. Is there any further discussion of the amendment?
Mr. Chairman.
Who seeks recognition? For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is
I
recognized.
too rise in opposition to the amendment. You know, what we're really debating here is powerful corporations buying the silence through settlements and NDAs. Silence rewards predators. It's that simple. Silence rewards predators. The predator of sexual malfeasance can move jobs, change states, leave without ever being questioned for their choice to leave, but not the survivors. Even a high-powered lawyer, like the woman who testified before this body last year who suffered sexual harassment in the workplace, was forced into silence without the choice to speak out. That's just wrong. Forcing women into a situation where they may face public retaliation, stigma, and fear of legal retribution is not only dangerous, it's wrong. Like my colleague, Rep. Buck, just said, currently the predator is isolated and protected by the silence. We must empower survivors to have the choice to not only speak out, but more importantly, warn their colleagues. That's a big underlying problem here. The silence that is bought makes predators protected and colleagues not protected, leaving them vulnerable. This is giving women a choice. This is a question of force and choice. The bill does not invalidate any contract. It empowers survivors to speak freely about what happened to her, should she choose to. What women want is to be free from sexual abuse and harassment at work. It's that simple. The only way to end the cycle is to allow those who want to speak freely to do so. Those survivors who don't want to speak publicly won't. Regardless, they don't need to be legally bound to silence in perpetuity. We pray these protections are never used, but have precautions as large, powerful corporations is an important measure. This is of particular importance to women. I'm a vice chair of the Bipartisan Women's Caucus. I believe it's an important to highlight the power differentials that still exist in the workplace, that still exist for women in the workplace. I was so encouraged to see similar legislation passed through the House and Senate, through the leadership of Sherry Bustos, Lois Frankel, and many, many others. Lift Our Voices is a coalition of survivors, of witnesses to workplace sexual harassment and assault. These women signed an onboarding, as they described, they signed onboarding paperwork on the first day of employment without knowing, and now live in perpetual silence, unable to share their trauma with friend, with clergy, with even family members for fear of being sued. Let me read just a short portion of the letter. The toll that is imposed silence takes on survivors is incalculable. Too often, NDAs are used to protect the predators, even while driving survivors from their jobs and chosen careers. Imagine lying to a prospective employer about the real reason you were forced to leave your job, because you would be sued for telling the truth. Imagine being unable to warn coworkers about a predator in their midst because your employment contract prohibits you from sharing any information whatsoever. We have the power today to reimagine the world that Lift Our Voices suffered and experienced. I move to submit the letter of Lift Our Voices to the record, Mr. Chairman.
Without objection.
Thank you. And I thank Mr. Cicilline, Congresswoman Bustos, Congresswoman Frankel, Congresswoman Jayapal, and many others for their leadership here. And I yield back.
Will the gentleman yield for?
I will yield to you.
Thank you. Mr. Chairman, I ask unanimous consent to include in the record a letter from a coalition of public interest organizations working to protect survivors and end domestic violence led by Terry Poor, Policy Director at Ralliance, a letter from more than 200 survivors and witnesses of sexual harassment and sexual assault impacted by non-disclosure agreements, and a statement from the record from the sponsor of H.R. 8227, the Honorable Lois Frankel of Florida.
Without objection. Who seeks recognition? For what purpose does the gentleman seek recognition?
Speak to the bill.
Gentleman is recognized.
So, I may have a question for Mr. Cicilline if he's available to answer it. As I read through this and I was listening, I think most of the discussion has assumed that we're talking about non-disclosure agreements entered into in the course of employment. But as I read the language of the agreement, I don't see any such limitation. Is that right, Mr. Cicilline, that it's not limited to employment context agreements?
That's correct. It would also apply to consumer agreements, for example.
Okay, so All right, so that broadens it even considerably beyond the purview that we've actually discussed. And it's hard almost to think of the other ways in which people might enter into a non-disclosure agreement. You just gave one that is new to me.
Yeah, I mean, so there are examples of people who have, in certain environments, been exposed to sexual harassment and sexual assault that would obviously want to have the ability to make those practices known. So yes.
Does the gentleman remember the Duke lacrosse case?
Do I remember? Yes.
So are you saying that this bill should protect the ability of that accuser to accuse those people falsely of sexual assault?
Oh, of course not. Look, this bill never authorizes or condones or makes permissible false allegations against anyone.
Okay,
that remains the province of existing libel and slander laws. If someone makes a false claim, we already have a robust mechanism to pay for the harm you caused by making a false claim. This bill doesn't change that at all.
All right, so if you have a situation like the Duke lacrosse case in which those young men's reputations were all destroyed by public accusations, what you're saying is they should be left to, there should be no situation in which that should be a matter of contract law. They should, even if there's a dispute and litigation doesn't get filed before, but can't be resolved that way. The only recourse those people should have, or people in that situation, would be suing for defamation.
I don't think in that case I don't think there was any NDA. And of course, anytime someone's reputation is damaged, they have under current law the ability to file a lawsuit and seek redress and be compensated for the harm that was caused. Nothing in this bill changes that.
So if someone is victimized by a false accusation, they should be remitted to their legal rights in court. But if someone suffers sexual abuse or assault, they should be in a favored classification. They should not be so limited, correct?
Yes, I mean, this is a pervasive problem with millions of victims of sexual harassment and sexual assault in a variety of contexts. I think we all take the position that that ought not be kept secret for any reason, particularly if that individual has been forced to agree to some provisions as a condition of their employment. So yes, I mean, I think there's a big difference. We have slander and libel laws that give people a mechanism to go to court if they've been falsely accused of something they didn't do, and they can be compensated. That system works quite well.
So those
this is a particular problem.
I'll reclaim the time. So those who are victimized by false accusations are entitled to second-class citizenship.
I think they're second-class citizens. Our court system provides a robust ability to go to court, sue, and be compensated for all the harms that were caused as a result of a false accusation being made against you.
But the court system prior to this bill also provides that robust protection to victims of sexual assault and
Except
harassment.
if there's a non-disclosure agreement that prevents them from talking about it.
It doesn't keep them from going to court, just like the
going
person
to court
whose
and saying
reputation's
nothing.
been destroyed.
Going to court and then
All right,
basically...
I'll reclaim my time. I'll reclaim my time.
I don't blame you for reclaiming.
No,
You sure don't want to hear the answer.
I just don't think talking over each other helps.
Okay, well then if you'll just let me finish
the
the answer. It's like you go into court but requiring that your mouth have a piece of tape over it.
Chairman,
But you
regular
don't.
order.
I'll reclaim
gentleman
it.
from
I
North
thank Mr.
Carolina's
Cicilline
time.
for the colloquy. I've got a few seconds left. Let me finish it. I think that's exactly the lack of symmetry that I am concerned about. Yes, people who are victimized by sexual assault and harassment suffer horrendous injury and they need to have full recourse. That's why we agreed to the change to the Federal Arbitration Act so that they can have full recourse to robust litigation. People whose reputations are unjustly destroyed by false accusations, like the Duke lacrosse players, they also are horribly injured, and they have rights to a robust litigation system. In that case, the claim is defamation or slander. But I see no justice in making one class of victims specially protected and the other class specially victimized. Why that's okay to everybody on the other side, I don't know, unless you believe all women. That is to say, if a woman makes a complaint, that is the last word. I don't think that's what justice requires. It requires an adversary system in which each side is heard and a jury of peers come to a conclusion. That's the American system of justice. I yield back.
Gentleman yields back. Who else seeks recognition? For what purposes?
I move the strike, Mr. Chairman.
What purpose does Mr. Jones seek recognition?
In reflecting on the legislation before this committee today,
Does the gentleman strike the last word?
yes. All right, Mr. Chairman, I
Gentleman
actually
is
moved the
recognized
strike
for
before.
5 minutes.
In reflecting on the legislation before this committee today, I am reminded of the words of women's rights activist Tarana Burke, who hails from my home state of New York. Ms. Burke is perhaps best known as the woman responsible for beginning the Me Too movement. She first did so back in 2006 as a rallying cry to let survivors of sexual violence and harassment know that there was strength in their numbers. When the Me Too movement finally swept the nation in 2017, Ms. Burke used her newfound spotlight to deliver the following call to action. Quote, "There has to be a shift in culture. We have to have a conversation about the systems that are in place that allow sexual violence to flourish. Our goal is not to take down individuals. It's to dismantle the systems that give them cover." Today, this committee is doing precisely that. We are heeding Ms. Burke's call for systemic change by dismantling a key legal tool that sexual harassers and sexual abusers in the workplace have hid behind for decades. This right here is what progress looks like, and I am damn proud to vote for this bill today. Workplace sexual harassment is an experience that is universal to both women and men. According to the National Sexual Assault Resource Center, 1 in 7 women and 1 in 17 men have sought a new job assignment, changed jobs, or quit a job because of sexual harassment or sexual assault by their employer. This scourge of workplace sexual violence and assault is not just an issue that plagues movie stars and TV personalities. The everyday victims of workplace sexual assault are our neighbors, our friends, and our family members. No one is immune. In New York, a 2019 study found that 1 in 8 working women and nearly 1 in 10 working men reported experiencing quid pro quo sexual harassment in the workplace, a brand of abuse where a victim's hiring, workflow, or opportunities for promotion are based on that victim's tolerance of another employee's sexual advances. This abuse is also intersectional, as the same study found that Black and brown employees were almost twice as likely to experience quid pro quo sexual harassment as their white peers. Other research paints an alarming picture for LGBTQ+ workers, as studies show that as many as 68% of these individuals have experienced sexual harassment or assault in the workplace. Even worse, only a small minority of these same workers ever reported these allegations to their employer. This culture of silence surrounding sexual assault and sexual harassment claims, facilitated by the enforcement of pre-dispute non-disclosure agreements and clauses, has driven countless workers from their jobs while allowing those who preyed upon them to remain unaccountable. The Speak Out Act would correct this injustice. If this bill were enacted in the years before the advent of the Me Too movement, imagine all the victims Congress would have saved from the Harvey Weinsteins, Bill Cosbys, and Donald Trumps of this world. It has been 5 years since the Me Too movement came to the forefront of American politics, and it is high time for this Congress to take definitive action to meet this moment. We began this process earlier this year when we passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, and I wholeheartedly supported that long overdue legislation. Going forward, I encourage my colleagues to come to the table to discuss whether the same type of action can also be used to curb the enforcement of pre-dispute NDA clauses for workplace abuse and harassment based on race, gender identity, and sexual orientation. But for now, to the victims of workplace sexual harassment and assault, I say to you that your stories matter, that you matter, that Congress cares, and that we will do everything we can to help you, and that we hear you. Before yielding back, I realize I've got a few seconds left. Mr. Cicilline, would you like for me to yield time to you so that you can help educate one of our colleagues about what actually happens in the courtroom under these NDA clauses?
I thank the gentleman for yielding, and I just was trying to make the point that if you have an NDA that prohibits you from discussing the conduct at issue, your ability to go to court is precluded. You can go to court, but it's as if you have a big piece of masking tape over your mouth, because speaking about the violence that was committed against you would be a violation of the NDA. So it's, you get to go to a courtroom, but you get to say nothing. So it's the likelihood you'd have any remedy is non-existent. And if I just may ask unanimous consent to include in the record a statement from Congresswoman Sheila Jackson Lee of Texas in support of this legislation.
Without objection.
yield back,
Gentleman's
Mr. Chairman.
expired. Who seeks recognition?
Mr.
What
Chairman,
purpose does the gentleman from Kentucky seek recognition?
Move to strike the last word.
Gentleman is recognized.
I'd like to yield time to Mr. Bishop from North Carolina.
I thank the gentleman from Kentucky. Mr. Cicilline, are you saying that you believe that if there's an NDA, a non-disclosure agreement, and then there's a sexual assault or harassment, and the victim files a lawsuit, that when that victim goes to court for trial or appears for a deposition, that the NDA prevents them from testifying about the event? Is that what you're saying to this committee?
It prevents them from speaking to friends, family, the press, to discuss or disclose the contents of the lawsuit.
Well, Mr. Cicilline, you're aware, aren't you, that gag orders are used constantly to prohibit the use of extrajudicial publicity to affect an ongoing judicial
We're talking about victim advocates, for example. This would prevent a victim of sexual assault from speaking to victim advocates in connection with that litigation. So I don't think that sort of silencing is appropriate, nor do I think most members of this committee.
It wouldn't have that effect either if the victim advocate were engaged by counsel to serve the client. That would not be true, that they couldn't consult and speak freely.
Will the gentleman yield?
It's not my time. Let me just finish this one point. To the extent the implication of what Mr. Cicilline said earlier is that there'd be some limitation in the ability of a sexual harassment victim to litigate because they couldn't speak about the event in the course of giving evidence in that proceeding, that is dead wrong. So I don't think, your subsequent discussion clarified it. What your concern is apparently is not that they'd be precluded from giving evidence, but they'd be precluded from going out and talking publicly about the lawsuit and saying what their allegations were in that context. If that's the situation, it's not unusual for people to be precluded from taking their lawsuit and then trying it in public.
Well, the
courts
gentleman,
prevent that all the time.
Will you yield for a question, Mr. Bishop?
With that, yes, I'd yield to whoever wants to go.
Thank you.
Well, it's Mr. Massey's time.
I'll yield to Mr.
Mr.
Cicilline.
Massey's time.
I think you and I have a fundamental disagreement. Are you suggesting that a non-disclosure agreement is completely vitiated by simply filing a lawsuit? Because it's not. A non-disclosure agreement precludes you or can preclude you from disclosing it to anyone. So you can't file a claim because you can't talk about it.
Reclaiming my time and yielding
That's
to
the whole
Mr.
point of a
Bishop.
non-disclosure agreement. Otherwise,
I'm yielding to
all people
Mr.
would do is
Bishop.
file a lawsuit, and then they can talk
Reclaim
about
this
it.
time.
It's Mr. Massey's time.
You certainly can seek counsel from an attorney, and
But
you
you
can
can't
file a
talk about
lawsuit,
it.
and you can give evidence.
That
in
is
the lawsuit.
not true. A non-disclosure agreement prohibits disclosure.
Will the gentleman
The
yield?
gentleman will withhold. The time is Mr. Massey's.
Who asked for? I yield the time to Mr. Gomert from Texas.
Okay, and I do appreciate any friend on the other side of the aisle that, as was said, will educate us on what goes on in the courtroom. I've tried cases in so many different courts, federal, state, military. I've been a judge. I've handled thousands of felony cases, thousands of civil cases. I got a good idea of what goes on in the courtroom. And I appreciate the chairman pointing out, this is clearly paraphrased, not exactly, but this is what it really means. Look, we've been violating the Constitution for years, stealing states' rights, and the Supreme Court's let us get away with it. So this is certainly going to be constitutional when we steal more of the states' rights. The truth is, the Supreme Court has recently indicated, you know what? The federal government's been taking away state rights, and we're going to enforce the Constitution. But anyway, I flash back when Democrats used to say all the time, Dred Scott was decided by the Supreme Court, it's the law of the land, and you Republicans are not going to change that. Well, it got changed anyway. So I would just suggest that we have an obligation to follow the Constitution, and regardless of who's on the Supreme Court, but particularly now, because this is a matter of usurpation of states' rights. I think there's a good chance, under the current state of things, this would be struck down as a usurpation of states' rights. And I go back to my point, when somebody has suffered through sexual harassment, their life has been turned upside down, the last thing they need is to have to go all the way to the Supreme Court only to find out the Judiciary Committee got overly ambitious, thought they could disregard what the Constitution itself said, take over states' rights, throw them aside, and lose at that point because we overreached. We shouldn't go there.
I yield back to the
Gentleman's
chairman.
time has expired. Who seeks recognition? What purpose does the gentleman from California seek recognition?
Move to strike the last word.
Gentleman is recognized.
This one's pretty easy for me, guys. Who wants a non-disclosure agreement? Sexual assaulters, people who commit sexual harassment at the workplace, sexual predators. Who does not want a non-disclosure agreement? Victims. So for some of my friends on the other side, you can come down on the side that would protect predators, or we can stand for victims. I think we'd all be better off if we stood up for victims. And I'll give you an example in this exchange between Mr. Bishop and Mr. Cicilline. If I recall, at Fox News, one of its anchors, Gretchen Carlson, experienced sexual harassment at the workplace. Under an NDA, she or anyone in a position like her would not be able to go talk to other employees who also may have been victims to try and find and stitch together a class. She would be prohibited from doing that. So whether you can go to court or not under an NDA, I'll leave that to better legal minds. But under an NDA, you would not be able to go talk to other colleagues of yours to find out if this is happening, and then in strength and numbers put together a class that could sue the corporation or the organization. And of course the benefits, as Mr. Cicilline pointed out, of having victim witness advocacy. The Duke lacrosse example, to me, frankly, is just absurd, because there are so many pathways in the courts if you are wrongfully accused through either defamation, and then frankly also, if someone files a false police report, that is also a crime. So you have a civil pathway and a criminal pathway to protect against that. So to suggest that in the very small, rare exceptions where people are falsely accused, this is coming from somebody who is always, nightly, on Fox News, falsely accused, there are a number of ways, if you want to go down that road, to seek legal remedies. However, there are an overwhelming number of women in the workforce especially, and as my colleague over here pointed out, black and brown women, more so than any other class, that happens more to them infinitely than someone who is falsely accused. So to say that the false accusations is the lowest common denominator here, and we shouldn't give anyone more rights than someone who is falsely accused, is frankly absurd. So I want to thank Ms. Bustos, Ms. Frankel, and the chair for bringing this forward, because we know that more than 1/3 of all American workers are bound by non-disclosure agreements or NDAs. And these are essentially efforts to silence someone's freedom to speak about their victimhood. The states are catching up, and it's time that we catch up. In 2019, the New Jersey legislature passed a ban on NDAs for all toxic workplace issues following a high-profile sexual assault that underscored exactly how much these silencing mechanisms harm survivors. Earlier this year, my hometown, or my home state, California, and our neighboring state, Washington, enacted similar bans on NDAs and non-disparagement agreements. Several months ago, legislation was introduced in New York State to do the same. Major employers have also moved to release all of their workers from NDAs. So we're actually behind the movement here, and it's time that we catch up. The Speak Out Act is a continuation of this important work. And with that, Mr. Chair, I'm going to yield to Mr. Cicilline if he wants to put a button on any of these arguments.
I thank the gentleman for you, and I think you made the point that I attempted to make, and I thank you for offering the time.
Reclaiming my time, this bill does not impact other types of NDAs, and it does not impact any NDAs that are part of a settlement, but it does preserve state laws that go further. Because NDAs exist both within forced arbitration clauses and separate from them, this legislation is vital to ensuring survivors can speak out about what happened to them on their terms. And with that,
Would the gentleman yield?
Sure.
I appreciate gentlemen yielding. I just want to clarify something, Mr. Bishop's question to Mr. Cicilline. As a proponent of this legislation and recognizing that there are some flaws that we will fix in this legislation before it hits the floor, I want to answer Mr. Bishop's question. If a woman is harassed or assaulted in the workplace and she calls 911, she can talk to the police officer despite a non-disclosure agreement. If she seeks to go to arbitration, she can tell her story in arbitration. If she seeks to go to court, she can tell her story. Nothing in a non-disclosure agreement can prevent a victim from certain disclosures. But it certainly does, and I think Mr. Bishop would agree, prevent a victim from disclosing to others in the workplace that are outside of the legal recourse. And I appreciate the gentleman for yielding, and I yield back.
Reclaim my time and yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye. All against say no. No.
No.
In the opinion of the chair, the noes have it.
As for recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch. Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries. Mr. Cicilline.
No.
Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu.
No.
Mr. Liu votes no. Mr. Raskin. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Ms. Demings. Mr. Correa. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia. Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Steen.
No.
Ms. Steen votes no. Ms. Escobar. Mr. Jones.
No.
Mr. Jones votes no. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush.
Bush votes no.
Ms. Bush votes no. Mr. Jordan.
Yes.
Mr. Jordan votes yes. Mr. Shabbat. Aye. Mr. Shabbat votes aye. Mr. Gomert.
Aye.
Mr. Gomert votes aye. Mr. Issa.
Aye.
Mr. Issa votes aye. Mr. Buck. Aye. Mr. Buck votes aye. Mr. Gates. Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Stubbe.
Yes.
Mr. Stubbe votes yes. Mr. Tiffany. Mr. Tiffany? Mr. Tiffany? Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Betts votes aye.
Mr. Benz votes aye. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Mr. Massey? Mr. Raskin?
Mr. Raskin votes no.
Mr. Raskin votes no.
Us Correa recorded.
Mr. Tiffany?
Mr. Correa, you were not recorded.
Correa votes no.
Mr. Correa votes no.
Aye.
Mr. Tiffany votes aye.
Ms. Jackson Lee? Ms. Jackson Lee? Ms. Jackson Lee on the Gohmert Amendment? Ms. Escobar?
Escobar votes no.
Ms. Escobar votes no.
Mr. Johnson of Georgia? You voted?
Mr. Chairman, how is Johnson of Georgia recorded?
Mr. Johnson, you recorded as no.
Ms. Ross? Is Ms. Ross recorded? Okay.
Ross voted no.
Are there any other members who haven't voted who wish to record their vote? Clerk will announce the result. Is Ms. Jackson Lee recorded? Ms. Jackson Lee? Would you like to be recorded?
She's giving a thumbs down.
Look at the screen.
Ms. Jackson Lee votes no.
Okay.
How will?
The clerk will announce the result.
Mr. Chairman, there are 17 ayes and 20 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute. I don't think we've amended. As amended. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. No. Opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 8227 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. No. The ayes have it, and the bill is ordered reported favorably. A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Strayapal?
Aye.
Ms. Strayapal votes aye. Ms. Stimmings? Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes no. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy?
No.
Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz?
Smith votes no.
Mr. Benz votes no. Mr. Owens?
Aye.
Mr. Owens votes aye.
Ms. Jackson Lee? Is Ms. Jackson Lee recorded? Oh, never mind, okay. Are there any other members who haven't been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 22 ayes and 13 noes.
The bill is agreed to. The ayes have it. The bill is amended as reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, in the nature of a substitute, including incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Votes have been called on the House floor, and the committee will be managing a bill on the floor immediately after those votes. Therefore, the committee will stand in recess until immediately after the conclusion of debate on the active shooter bill on the floor. The committee stands in recess.
All of them.
My mic's on. Okay, do it again. Pursuant to notice, I now call up H.R. 7566, the Stop Human Trafficking in School Zones Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 7566 to amend Title 18 United States Code.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 7566, the Stop Human Trafficking in School Zones Act, continues this committee's focus on strengthening federal efforts to eliminate all forms of trafficking in persons, both domestically and internationally, through prevention, protection of victims, and prosecution of traffickers. This bipartisan legislation would increase the maximum penalty under current law for committing child sex trafficking within a school zone or on the premises, or within 1,000 feet of school-sponsored activities. Human trafficking is a multi-billion-dollar criminal industry that denies freedom to 24.9 million people around the world. It is a reprehensible crime that touches communities across the country, from major cities to suburban enclaves and rural back roads, and comes in many forms. The crime of sex trafficking of adults involves exploiting adults by causing them to engage in commercial sex using force, fraud, or coercion. However, when a person under 18 years old is induced to perform a commercial sex act, it constitutes a crime of sex trafficking regardless of whether there is force, fraud, or coercion. Of the 22,326 trafficking victims and survivors identified through contacts with the National Human Trafficking Hotline in 2019, at least 5,359 were under the age of 18. And in 2021, the National Center for Missing and Exploited Children received more than 17,200 reports of possible child sex trafficking. Sex trafficking can cause devastating, sometimes irreparable harm to young people who fall prey to cunning traffickers. Recruitment, grooming, and the eventual trafficking of victims occurs in person and online through a variety of calculated methods. Although the internet and social media make up a large portion of first encounters, traffickers also target vulnerable children and youth by frequenting locations that young people frequent, including schools. Traffickers also use peers and classmates who befriend their targets and slowly groom them for the trafficker by forming relationships with fellow students while at school or school-related gatherings. These proxies may bring their unsuspecting targets along to parties and other activities to slowly bring them into the criminal enterprise. Students might also encounter traffickers while traveling to and from school. Being masters of manipulation, traffickers prey especially upon vulnerable children and youth, using psychological pressure, intimidation, and oftentimes drugs to control and sexually exploit them for the trafficker's benefit. They secure their target's trust, fulfill their needs, isolate them, and eventually exert complete control over them. Once they've established sufficient control over their prey, traffickers sell their victims at private parties, illicit massage parlors, hotel and motel rooms, strip clubs, truck stops, and online. And they use technology, such as cellular phones, to control their victims remotely. No child is immune from becoming a victim of sex trafficking, regardless of their race, age, or socioeconomic status. Whether we're talking about drugs, guns, or sex trafficking, children and youth deserve safe learning environments that allow them to learn, thrive, and focus on their academic success, free from any elements that might cause them harm. That is why I was pleased to join Crime Subcommittee Chairwoman Sheila Jackson-Lee and Representative Michael McCall in the introduction of H.R. 7566, which would punish those who dare to invade the sanctity and security of our schools to recruit, entice, transport, or commit any other acts that constitute child sex trafficking under current law. This legislation would establish a sentencing enhancement that increases the maximum penalty by 5 years for causing a minor to engage in a commercial sex act within a school zone or on or within 1,000 feet of the premises where a school-sponsored activity is taking place. While this bill would not increase or change the existing penalties for commission of the underlying offense, it provides additional punishment to those who invade what ought to be a safe space for our children. I thank Chairwoman Jackson-Lee and Representative McCall for introducing this bipartisan legislation with me and for their commitment to combating human trafficking of all kinds. I urge all my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Human trafficking, especially the sex trafficking of children, is an abhorrent crime, and all convicted offenders should face the most serious criminal penalties. This bill will provide increased criminal penalties for human trafficking or coercing a minor to engage in illegal acts in school zones or near school-sponsored activities. Texas recently enacted a similar law. According to the Texas State Senate bill report, 55% of trafficking survivors in Texas were trafficked while at school or school activities. The Justice Department's Office of Justice Programs reports that traffickers are known to recruit at schools and at after-school programs. This legislation doesn't address, though, the root cause of the problem, our unsecure southwest border. Tragically, we know that human smuggling and trafficking occurs daily at the southwest border. This committee has failed to focus on fixing the completely broken immigration system or the Biden border crisis, which cartels and other organized criminal organizations have exploited to smuggle and traffic children into our country. Cartels and criminal organizations continue to take advantage of the Biden administration's complete and abject failure to secure our southern border. We should focus the committee's efforts on securing the border to prevent the type of human trafficking this legislation will address. With that, Mr. Chairman, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7566, offered by Mr. Nadler. Strike all that follows after the enactment
Without objection,
clause.
the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes two changes to the underlying bill. First, it changes the name of the bill to the No Trafficking Zones Act, or the NTZ Act. Second, because we know that traffickers recruit, groom, and control their victims using cell phones, the internet, and particularly social media, this amendment adds a provision that increases the maximum penalty by 5 years for contacting a minor to persuade or entice the minor to engage in illegal sexual activity using cellular technology or the internet in violation of current law, while the minor is within a school zone or on or within 1,000 feet of a school-sponsored activity. I urge all my colleagues to support this amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, to strike the last word.
Gentlelady is recognized.
Human trafficking kills. It kills you physically, spiritually. It kills your life. God forbid that you're never found. That is the scourge of human trafficking. I beg to differ with my good friend from Ohio. I abhor smuggling of human beings. But human trafficking occurs at the church door, the grocery store, the sports arena, the entertainment center, and yes, America's schools. Can you imagine that your children would go to school and either lose their life through the violence of guns or never come home again, and you've never found them? Houston, Texas, has been the epicenter of human trafficking. A hearing almost a decade ago, then Chairman McCall evidenced that, and the people cried and pled for relief. That's why I'm very grateful for this opportunity to present this to my colleagues. I want to thank Chairman Nadler for joining this legislation, for it then further enhances its potential and its prominence. I want to thank Aaron Hiller and Amy Rutkin for working so hard with my subcommittee staff of Keenan Keller, Nicole Bannister, Natalie Knight, and my Deputy Chief Counsel, Maury Gray. This is a bipartisan bill, and again, I thank Ms. McCall for joining with me. The No Trafficking Zones Act would ensure that schools across the country are safe spaces for learning and academic exploration and free from the menace of sex trafficking. This legislation would establish a sentencing enhancement of up to 5 years for any person who commits the offense of child sex trafficking or coercion and enticement of a minor within a school zone or on the premises of or within 1,000 feet of a school-sponsored zone. In 2020, 11,193 instances of potential human trafficking were reported to the United States National Human Trafficking Hotline, and an estimated 25% of all human trafficking victims in the country are in Texas at any given time, many of whom are minors. A large segment are minors, again, that are never found. Minors who have run away, minors who have not run away. And sometimes, unfortunately, law enforcement will say to the families, oh, they've just run away. At least 5,359 of trafficking victims and survivors identified through the hotline in 2019 were under the age of 18, and the National Center for Missing and Exploited Children received more than 17,200 reports of suspected child sex trafficking in 2021. Many of these underage victims of sex trafficking are students in the school system across the country. A 2018 survey reported that 55% of the young sex trafficking survivors in Texas were trafficked while at school or school activity. 60% of trafficked adults say they were first groomed and solicited by trafficking on school. This legislation will give law enforcement more tools to make sure that anyone who dares to go near a school is perpetrating a criminal offense. Members of this committee know well from our many discussions concerning sex trafficking that children are sexually exploited in a number of ways. They are sold by family members, exploited by gangs, and others who seek out vulnerable children and youth by offering food, money, or place to stay. Some young people are even trafficked by their schoolmates or former students. Some come from out of the country, yes, but they get to our schools and they are then enticed there. Traffickers gain the trust of their young prey gradually, sometimes buying gifts, making promises, or fulfilling unmet needs. We heard that from our young witnesses and others that I've interacted with. Over time, some of them thought they were their best friends. Traffickers begin to play a major role in the victim's life while creating distance between the victim and their family, because they walk away with the traffickers and friends and drawing them away from their homes for increasingly longer periods of time, never to be seen again, and sometimes losing their life. The young target does not return home at all, and the trafficker assumes control out of every aspect of the victim's life, maintaining control through threats, violence, blackmail. Let me be very clear, this is more lucrative than drug trafficking because you use that body over and over and over again for sex. Traffickers seek out young people who have noticeable vulnerability. We must acknowledge that no child is truly safe. During the Crime Subcommittee's recent oversight hearing on federal efforts to combat human trafficking, we had a young woman present as a guest, Courtney Litvak, who grew up in a loving church-going family and attended an upscale suburban high school in Texas, but nevertheless found herself being sold for sex online over and over again. And the trafficker, with ties to her high school like a friend, became a friend to her in her vulnerable time. She was also groomed by other students while at school using social media. Courtney's story should be told. I ask my colleagues as I proceed in this debate to help the children and support H.R. 7566 for the children. Save the children. I yield back.
Gentlelady yields back. For what purpose the gentleman from Ohio seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. Human trafficking is an ongoing challenge facing us both at home and abroad. In addition to being on this Judiciary Committee, I'm also a senior member of the Foreign Affairs Committee, and in that capacity, I've spent a significant amount of time working on this critical issue. In fact, a few years back, I worked with Senator Marco Rubio on the Girls Count Act, which would help prevent human trafficking abroad by ensuring that all children, especially girls, receive a birth certificate when born. There's an awful lot of children that are born, and they're oftentimes trafficked because they're particularly vulnerable because there's no record that they even exist. The legislation that I just mentioned was signed into law by President Obama and has helped prevent girls from disappearing in human trafficking rings abroad. Domestically, human trafficking of our children by master manipulators preying on our youth is an abhorrent crime and can have devastating immediate and long-term consequences. I think we can all agree schools can and should be safe havens for the students. While this legislation is a step in the right direction, I believe, and I'm inclined to support it, there are further steps this committee can take to disrupt human trafficking networks here at home. Specifically, we should be addressing the trafficking that occurs daily at our southwest border. That starts with making sure that our southern border cannot be used by criminal trafficking networks to smuggle vulnerable children and women into this country. Unfortunately, because of this administration's refusal to secure the border, we reached crisis stage. Since he took office, President Biden has reversed just about every one of President Trump's successful immigration policies. The Biden administration stopped construction on the border wall, ended catch and release, and has practically abandoned enforcement by ICE altogether, just to name a few of its misguided policies. The situation at the border is an unmitigated disaster, and unfortunately, the massive influx of illegal border crossings that we're experiencing only makes it easier for human trafficking networks to flourish by exploiting our lax border security. In addition to protecting our children in schools, this committee ought to also focus its efforts on securing our southwest border to prevent the type of human trafficking that this legislation seeks to criminalize. So whereas I support this legislation and would commend the offering of it and the committee's time being taken up for it, that's fine. But there's so much that this committee has ignored. The fact that our border is so porous and that it's intentional policies by this administration that's led to the chaos down at that border, it's just unacceptable. This committee ought to be better than that, soon will be better than that. But I would commend, again, the committee for taking time to focus on this. That's good. But what we're doing is we're missing the forest here. This bill is a tree, but the forest, people are coming over in droves into this country right now, and many of those, unfortunately, are being trafficked. They're bringing drugs into the country. We've got thousands and thousands of people dying from fentanyl that's being brought here. So, again, thank you for bringing this bill up, but we can do better. Let's look into those other things as well. And I yield back.
Gentleman yields back. For what purposes the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I want to thank you, Mr. Chairman, and also Chairwoman Sheila Jackson Lee, and also Representative Michael McCall for introducing this really timely and very important piece of legislation. One of the most important things that I think that we can do as lawmakers and as parents is to just do everything that we can to protect our children. Our children deserve to live a life free from fear, free from violence, and free from pain. Children deserve to go to school, to engage in learning, make real and fast friendships, and grow as individual human beings. Children deserve to go to school without worrying that the adult on the playground who is claiming to be their friend, someone who's trusted, someone they can confide in, is really attempting to entice them, coerce them into sex trafficking. That is why I'm so proud to support the Stop Human Trafficking in Schools Zones Act, to be called the No Trafficking Zones Act, H.R. 7566. Last year, the National Center for Missing and Exploited Children received more than 17,200 reports of possible sex child trafficking. Over 17,000 potential incidents of a child being forced into sex acts for commercial gain. Children who could be your daughter or your son or your grandchild, because this is not something that happens in certain communities or with kids that come from certain backgrounds. Child sex trafficking happens all over in each and every one of our districts. In my home state of Georgia, which has now become an epicenter as well for sex trafficking, it's reported that on any given night, approximately 100 young girls are sexually exploited. On average, 3 times per evening in Georgia, a young girl is being trafficked to adult males. These are alarming and disturbing figures. And these numbers are unfortunately even worse in other states. We must do everything in our power to protect America's children. This piece of legislation would increase the punishment for human trafficking in school zones. And the ANS introduced by the chairman would also increase the maximum punishment for coercing or enticing a minor into commercial sexual activity while in school. Schools should be a safe zone for our children, not a zone for human trafficking. So I strongly urge all of my colleagues today to vote vote yes on H.R. 7566. And I yield back the balance of my time.
Gentlelady yields back. For what purposes Ms. Dean seek recognition?
Mr. Chairman, to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and I rise in support also of the No Trafficking Zones Act, NTZ Act. Just last month, I spoke about 4 individuals from Reading, Pennsylvania, who were convicted of human trafficking on June the 2nd. Since then, Rodney Kent, a Philadelphia man, was convicted on June 17th of sex trafficking a woman on the now largely defunct Backpage.com. Although Mr. Kent will face years in prison for his vile actions, the survivor, her family, and her community, my community in Philadelphia, will have to live with the pain and fear as a result of this disgusting crime. To those who participate in this evil as a means to make a living, as your occupation, we are looking for you. We will find you, and you will pay the price. The No Trafficking Zones Act of 2022 makes this commitment clear. The bill punishes those who target children where they spend the majority of their time and should spend their time safely at schools. I'm proud to lend my support to the bill and commend the bipartisan efforts of Representative Jackson Lee and Representative McCall and Chairman Nadler for your continued leadership on this issue. The National Center for Missing and Exploited Children received 17,200 reports of possible child sex trafficking. We have to make it abundantly clear that we will protect these children, boys and girls, everywhere, to include their schools. I urge support of this common sense measure, and I yield back the remainder of my time. Thank you, Mr. Chairman.
For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and I want to thank you and the sponsors of this bill for bringing it forward. I can't think of a worse, most shameful behavior on the part of one human being than to prey on children, particularly tender-aged young children in our public schools and our charter schools or any of our schools. You know, as some of my colleagues have already said, children deserve to make sure that their schools are safe places, places where they can be free from fear, not just from gun violence, but from anyone who might want to kidnap them and exploit them, anyone who might use them for any human trafficking. Mr. Chairman, I graduated and attended and graduated from the FBI Citizens Academy in the Houston region. And I can tell you that the session that brought almost all of us to tears was the session that was on human trafficking, especially when it involved children. The very idea that there are men in this country, and it's all about demand, who seek out the youngest of the most tender-aged children, that we heard of a case of even toddlers being picked up and preyed upon. This is a very shameful part of our American life. It should be eradicated. We need to make sure that we don't have people preying on their children at school, at the malls, at the theater, at church, or anywhere that they might gather to play. The idea that people would get them and use them and sell them is just abhorrent. So I strongly support this bill, and I hope that all our colleagues can do that, not only here in committee, but the full House and onto the Senate. So, Mr. Chairman, thank you again for bringing this, and thank you to the chairwoman for bringing this forward. I strongly urge support of this bill.
Gentlelady yields back. For what purposes Mr. Biggs seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7566.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I appreciate Ms. Jackson Lee's effort and the chairman's effort to increase penalties for those individuals who prey on children. The depravity that we see must be punished appropriately and must act as, that punishment must act as a deterrent against future issues. I do want to bring up one question that I have before I get to the heart of my amendment, and that is this. On page 5 of the ANS,
Where's the A&N?
I'm only concerned about this because I think this is important, because much of sex and human trafficking occurs through recruitment at public schools by fellow students. It actually does. And I'm curious as to whether the 5-year extended penalty would be applicable to a juvenile who is there. So I don't need to have an answer now, Mr. Chairman, but I do think that's important to get to the bottom of. What my amendment does, though, is it builds on the efforts of Ms. Jackson Lee in this bill by adding additional language to the bill, which provides for additional penalties for individuals who smuggle minors into the United States, transport them around the country, harbor them, or encourage or induce them to enter the country illegally. We have an unbelievable amount of human trafficking coming across our southern border. I think of down in South Texas, and same thing in south of the border in Arizona. This trafficking is outrageous. The Gulf Cartel, the Cartel del Noreste, which is part of Los Zetas, they are trafficking in children across. We know that as they traffic them into our country, many will later become victims of sex trafficking, and some are brought into the country explicitly to become victims of sex trafficking. It's my opinion we should be stopping or trying to prevent sex trafficking as early as we possibly can. Increasing the penalties for smuggling, transporting, and harboring these children will do that. We are currently experiencing the worst border crisis in American history, and perhaps even in the history of the world. Each month, CBP is encountering hundreds of thousands of illegal aliens at the southwest border. Those encounters do not even include the tens of thousands of those who get away, who enter the country illegally each month. The impacts of the crisis are especially horrific on children who are brought into the country illegally and then trafficked throughout the country. Every time I go to the border, I hear stories from Border Patrol agents about children who are being brought into the country and the horrors that those children have endured. When I was at the border just a little over a week ago, there were hundreds gathered together. And while they were gathered together, and one Border Patrol agent was trying to keep them pacified while they waited to be transported for processing, the radio was on, and we could hear of those who were running to get away. Those people are dangerous to this country. This amendment would provide an additional increased penalty for those who violate our laws by smuggling minors into the United States, transporting them around the country, harboring them, or encouraging or inducing them to enter the country illegally. That would be a small step to prevent children from experiencing the dangers and the horrors associated with illegal immigration. I hear my colleagues talking about their concern, and I believe that concern to be real. It is no less than the concern that I believe everyone on our side has. Please adopt this amendment so that we might actually provide additional deterrence to stop human and sex trafficking of minors at the border. It would be a tremendous deterrent, and that's what a lengthy sentence is meant to do: provide specific deterrence, general deterrence, as well as a punishment. So that, Mr. Chairman, I encourage everyone to vote yes for this amendment, and I'll yield back.
The gentleman yields back. I recognize myself in opposition to the amendment. Although the amendment is well-intentioned, it goes beyond the operative scope of the bill, which is directed at sex trafficking in schools. The amendment is directed at illegal entry and human smuggling. So it's beyond the scope of the bill. And although its intention is good and maybe it should be fitted in a different bill, it does not belong in this one. I yield back. Who else seeks recognition? For what purpose does Mr. Roy seek recognition?
Speak to the amendment.
Gentleman is recognized.
So I believe that the gentleman's purpose, with respect to the chairman's position, that it is not related to the underlying purpose of targeting sex trafficking.
Not that it's not related, it goes beyond.
Okay, but we're talking about the problem of human trafficking and of sex trafficking in the United States. And the gentlelady's measure is designed to provide an enhancement to the existing penalties because of concern that there is targeting of children at schools. I mean, that's my phrasing.
Yes.
And I think the gentleman from Arizona is wanting to address the same topic of human trafficking, sex trafficking, targeting of kids and so forth, believing that this is being driven heavily, whether it's our schools or otherwise, by virtue of the situation at our border. And I would suggest that for that reason, it is very much on point, and I'd be happy to yield to the gentleman from Arizona if he wants to add to my point.
Yeah, I thank the gentleman for yielding. Why I think this is so critical and is merely an extension of what the underlying bill is this bill is attacking and actually improving perhaps Section 1591 of Title 18. And 1591 deals specifically with sex trafficking of children or by force, fraud, or coercion. And whereas the gentlelady's bill is dealing with sex trafficking of children at schools, my amendment actually just extends that to those 1591 protection to children who are being sex trafficked across the border, and many will end up in school. Some of the individuals that are being trafficked will end up as being recruiters in school. So this actually, in my view, is kind of an exponential enhancement to the underlying bill. With that, I'll yield back to Mr. Roy.
Well, and I think the gentleman from Arizona, that was my understanding of what the intent of the gentleman from Arizona was not to get sort of beyond the purpose of the gentlelady's measure as much as to enhance the measure. As you responded to, obviously in Texas, we have an inordinate number of individuals that are being trafficked across our southern border into the United States. If you talk regularly with Border Patrol or law enforcement officials, whether it's in Houston, where the gentlelady resides, San Antonio, which I represent, South Texas obviously in particular, and large number of underage, particularly girls, children generally, that are being trafficked, taken to stash houses in San Antonio, taken to stash houses in Laredo, taken to stash houses in El Paso, taken to stash houses in McAllen and Houston and Dallas and throughout the state, and then distributed throughout the country. And then often in the case of these young children, if they're coming in, if they're in Texas, as the gentleman refers, and I assume this is the case in Arizona, often end up in our schools. And we're trying to say, well, let's address that. I think the gentleman is trying to say, let's address that by recognizing the benefit that would, I think, yield from an enhancement as a result of that trafficking in order to minimize the danger to the children that are being trafficked across our border and then end up in the schools, be they in Texas heavily or throughout the country. For that reason, I would support the gentleman's amendment, believe that it's important. And I think it's important that we continue to have this discussion about how much trafficking is tied to our open border. And to be clear, in my conversations when I was in the Office of the Attorney General in Texas and dealing with the human trafficking, there is very much a trafficking element that is alive and well, totally separate from and irrespective from the border criminal activity. No question about that. And we need to address that. But there is a strong nexus to the trafficking across our border. It is, in fact, horrific. It is, yes, cartel-driven, and yes, it is heavily tied to the border, but it is also tied to the networks that infiltrate into the United States in criminal elements. And I think it's particularly true in Texas, as I suspect the gentlelady would agree with, whether or not she agrees with having this added on to the underlying measure. With that, I would yield back if the gentleman wants it, or yield back my time.
Just, I thank the gentleman for yielding. I'll just be quick. I appreciate the chairman saying that maybe this would be more appropriate on another bill. I've been looking for another bill that the majority would introduce that I could go with, because none of the bills that I've introduced have been heard by the majority, and I understand that. But, Mr. Chairman, I would urge you to rethink your position here. I think these go hand in glove. They're important, and with that, I thank the gentleman for yielding to me.
Yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
Chairman,
For what purpose does the gentlelady from Texas seek
strike the
recognition?
last word.
Gentlelady's recognized.
I think we have enough collegiality in this room for me to say that I'm empathetic to the concerns that Mr. Biggs raises, but the idea of this particular legislation is to target a scourge in the United States that is not only extensive, expansive, but growing. It is not ending, it is not going down, it's going up. And frankly, if individuals who are undocumented are in our schools, which school districts make that determination, this bill covers them, because it focuses on young people being snatched from schools, as my colleagues have said, never to be seen by their family members again. This amendment creates an enhancement for violations of 8 U.S.C. 1324, while my bill creates enhancement to violations in 18 U.S.C. 1591 and 2422. And so, in essence, this steers us away from the core that I think will provide coverage for children who have been brought to this country, as my colleague wants to suggest, in whatever form, but they are in school. And they can be victims of trafficking, and this legislation is to gather the armor that law enforcement, prosecutors need, as traffickers have infiltrated every known form of communication. So I've already stated that if they're on the grounds or within a reasonable distance, that they will be held accountable under this bill. But in addition to my colleagues, if they are using messaging apps, social media, gaming platforms our children use most frequently, leaving the most vulnerable exploitation, they are in the eye of this legislation. With the proliferation of social media and the myriad ways in which we communicate with one another, traffickers have put these same means of communication to their own use to find, target, lure, groom, victimize, maintain control over their victims. Meanwhile, buyers are using technology to find and purchase sex anonymously. We've got a scourge that we've got to focus on in this legislation. 7576 is eagle eye on the scourge and the dastardly acts of snatching out children from a safe place that their parents should expect to be safe, and that is the schools. And the access that our children have to the internet and cell phones and smartphones makes it easier for traffickers and buyers to communicate with children and youth, even when they're at school or attending school-sponsored activities. It's unacceptable, and it is important that we get rid of it through a process that finds these persons where they cannot make the profit over and over again. I think the gentleman's amendment takes us off into another pathway, and I believe we've got to, in essence, make one step at a time. As I indicated, again, this is a profitable business, and my belief on smuggling is that it is distinctive from the crux of what we are speaking of. And for that reason, I would ask the gentleman to work with us and to ensure that we keep our eye on this legislation because it is known that I have written legislation, have opposed human smuggling. It is a question that is addressed in many instances in the immigration space. because human trafficking is distinct from the separate crime of human smuggling, it is a misconception that human trafficking requires crossing a border. In fact, it does not require movement at all. By contrast, human smugglers engage in the crime of bringing people across international borders through deliberate evasion of immigration laws, often for financial benefit. While human trafficking and human smuggling are distinct crimes, I can assure you that we will help your cause by passing this legislation, because in many instances, those who have been smuggled will be subject to being trafficked inside the United States. I believe the four corners of this bill captures the crux of what was intended in Texas, what is intended by the 12 letters that we have from organizations all over the nation, and as well to make sure that our schools are safe and our children are safe. I would have to oppose the gentleman's amendment because I think there are two distinctive aspects, and human trafficking is being targeted here. Let's finish this business and save our children. With that, I yield back.
Gentlelady yields back. If no one else seeks recognition, the question occurs on the amendment. All in favor say aye. Aye. Opposed, nay. No. And the opinion of the chair, the noes have it. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
We need a heads up before. Yeah, this is not.
Ms. Jackson Lee?
Yes.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
And then you've got 6.
Ms. Bass?
No. You have a person.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Dimmings? Ms. Dimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
How is Swallow recorded?
Mr. Swalwell, you're not recorded.
No.
Mr. Swalwell votes no.
How is Escobar recorded?
Ms. Escobar, you are not recorded.
Escobar votes no.
Ms. Escobar votes no.
Mr. Raskin?
Raskin votes no.
Mr. Raskin votes no.
Recorded.
Ms. Bush, you are not recorded.
Bush votes no.
Ms. Bush votes no.
Mr. Chairman, how am I recorded?
Mr. Cicilline, you are not recorded.
No.
Mr. Cicilline votes no.
Aye. Shabbat, aye.
Mr. Shabbat, you'll have to turn your camera on.
Mr. Shabbat, you have to turn your camera on in order to be recorded.
Crack staff's trying to.
So confident.
That's not Shabbat.
Now we just need to see Mr. Shabbat's face, not his staffers.
We see somebody.
Aye.
Mr. Shabbat votes aye.
Okay. Clerk, are there any members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 17 ayes and 20 noes.
Then the amendment is not agreed to. Are there any further amendments to the amendment nature of a substitute? For what purposes, Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
Reserve a point of order.
The clerk will report the amendment. Point of order is reserved.
Thank you, Mr. Chair. I'm glad to see that.
Wait. Clerk needs to report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 7566, offered by Mr. Fitzgerald.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chair. So I'm glad to see that the last amendment was considered germane. I think that the members will find that this is, you will as well, Mr. Chair. This is kind of an amazing discussion that's going on here this afternoon, a debate in the Judiciary Committee about a bill with members on the other side of the aisle admittedly saying that this is very tightly focused and we're only aiming at controlling human trafficking in and around school zones. When there is an absolute pipeline of narcotics and teenagers and kids that are coming across the border on a daily basis. And a lot of these people are being trafficked, not in school zones, but in truck stops and in strip clubs and in drug houses around America, being handed over directly to pimps that are part of the cartels on both sides of the border. So whether it's coming out of McAllen or the San Diego sector or whomever you talk to, whether it is Border Patrol or Homeland Security, it's an absolute pipeline of narcotics and kids coming across. And yet we're sitting here having a discussion about ignore that. Look the other way. Pretend that that's not happening at the border after this committee specifically has brought it up again and again and again in every hearing with a full discussion about border security. Where do you think these people are coming from? Homegrown? This is all a homegrown issue? This has nothing to do with what's coming across the border? That's unbelievable that we're having this discussion today in this format. And then, Mr. Chair, I mean, for you to say this goes beyond, that Mr. Biggs' amendment goes beyond that. It's too broad. It goes too far. Are you kidding me? That's the problem. That's what we've been talking about for the last year and a half. How do we get control of the border so that we can get control of the narcotics, so that we can get control of the human traffickers and the cartel? That's what this bill should do today. This amendment that I have before the committee will increase the punishment for sex trafficking of children by entering the United States illegally as described in 8 U.S.C. section 1325. That is what needs to be done. So you can all pat yourselves on the back and say, this is an awesome bill. I can run on this bill back home. I can talk about, listen, I stopped human trafficking in the school zone back home in my district with complete disregard for all the individuals that are coming across the border on a daily basis. Turn on any news channel. Turn on any 24-hour news channel, and what you'll see are live shots from the border. Is it just adults? Is it just adults coming across? No, it's kids. It's kids. And a couple of members of the other side, you got dangerously close to admitting that this doesn't address that. It's unbelievable to me that we're having this discussion without addressing the real issue, which we have been pounding on and bringing up on a regular basis, specifically in this committee. If we don't address this here, I'm not sure what it's going to take. But like I said earlier, there are all kinds of pockets where these kids are being exploited. There's a pipeline. It comes directly out of the western states. It goes through Denver. They jump on I-90, I-94, I-35, and they end up all over the United States, these kids. But guess where they come from? We know where they're coming from. They're coming from the border. And this Judiciary Committee will not do anything about it. And the idea that you would have the guts to bring up a bill and dance so close to the real issue and then pretend that it doesn't exist is unbelievable to me. I yield back.
Gentleman yields back. I'll recognize myself in opposition to the amendment. It's essentially the same amendment and the same argument as the last amendment. This bill is narrowly focused on child sex trafficking in school zones. The amendment deals with human smuggling across international borders. It's way beyond this bill. It belongs as a separate bill. On that count, I would, as I did the previous amendment, oppose this one. I yield back. Are there anyone else seek recognition on this amendment? For what purposes, Mr. Biggs seek recognition?
Let's strike the last word.
Gentleman is recognized.
I thank the chair. Look, I appreciate this amendment, and I support this amendment, and it's similar, but not exactly the same, but the argument's the same. But I have to point out one thing. I thought I heard someone in an argument last that this underlying bill addresses what is a huge problem for school recruitment and sexual and human trafficking arising in schools, and that is the social media issue. I've gone back and read this bill 3 times while we've been going. I don't see anything about social media deterrence in here, or enhancement, or anything like that, and yet 55%. Since 2000, all of the stuff in the current years, 57% of this arises through social media. So this really, you're not getting it there either. And then I have to say that I'm like Mr. Fitzgerald. I'm kind of bewildered.
Would the gentleman yield?
We're
the gentleman yield for a moment?
Yeah. If you want to address that, sure, Mr. Chairman.
Yeah, I just want to address
help me
Section
that.
2422, which is amended in Section 4 of the bill, says whoever using the mail or any facility or means of interstate or foreign commerce or within the, that includes social media.
Oh, but that's in the underlying statute.
Yes.
Okay, that's not in the A&A.
Yes, and that's why.
Okay, fine. Okay, yeah, I'll accept that. But let's get to this notion that I think is so interesting here, and that is the argument has been made. This bill is narrowly crafted. It's narrowly crafted to deal with a very narrow section of a really big problem. And there isn't anybody in here who doesn't think children being sex trafficked is not a really pernicious problem. But you want to deal with it, this narrow thing. Why don't we expand it and expand the field of the fight to where we know it's huge? It's on the border. This is what I said last time when we had the poster thing about human trafficking. That's why I said you should be putting this up in the processing centers along the border. Why? Because there's recruitment going on there. There is coercion going on there. And so why are we not trying to stop this? Why are we saying, okay, this is good to have a narrow thing? I'm begging you, please, recognize the expansiveness of the problem and support an amendment that will address something more than, I mean, think about it. It's like saying we're going to deal with the French fries when we go to a fast food restaurant, but we're not going to go to the whole Happy Meal. We should be expanding it to get the whole meal as much as we possibly can here to stop this. Well, it's baffling to me how you can make the argument that we're just going to narrow this thing and we're not going to be concerned about anybody else because we've got this narrow thing. And I'll yield to Mr. Fitzgerald if he needs time.
I thank the gentleman for yielding. Mr. Chair, I mean, the consideration would be that clearly there are many other places where human trafficking is happening on a daily basis across the nation. And here we are debating just the school zones. It doesn't make any sense. This is an issue where law enforcement and those that deal with this issue on a daily basis, whether it's social services or any other entity, they will tell you that these are unfamiliar faces that suddenly emerge in any community, and they do in very specific targeted places that I mentioned before. We had this issue in my district in the strip clubs. And there were communities that shut down strip clubs in their backyard because of, specifically, the human trafficking associated with those buildings. This happened in my district. I don't know why we're not going to just deal with the issue now instead of just simply saying, listen, we're going to focus on school zones. It doesn't make any sense to me. I yield back.
The gentleman yields back. Does anyone else seek recognition? For what purpose does the gentleman seek, well, what purpose does Mr. Gibbs seek recognition?
For who?
I'm sorry.
Bishop.
Mr. Bishop seek recognition.
Strike the last word, I think.
Gentleman is recognized.
Yeah.
Let me withdraw my reservation, which has not been withdrawn. Thank you.
Yes, yes.
I just wanted to, at this point, I think there'll be another amendment I'll go a little fuller on, but right now, I just wanted to revisit something that was said about social media in Mr. Biggs' colloquy, Mr. Chairman, with you, and I just wanted to just understand what the bill does with respect to that. Do I understand correctly that the effect of the language on page 5 is that if a sex trafficker solicits a child on campus by means of a direct message that they send from, farther than 1,000 feet from school, but if the child is in that location for a reason that's not a school activity, that this enhancement would not apply? Any of your lawyers available could speak to that?
I don't think so.
I could restate it.
Restate the question.
I'll try it. It's a little tricky, but I'm looking at this language on page 5, lines 13 to 16, and I was trying to factor that together with what was said earlier by you, Mr. Chairman, about social media being covered, and I was trying to understand how does that relate to the 1,000-foot school zone, the 1,000-foot zone you're trying to apply a penalty enhancement to. And so if I read this language right, if a prospective sex trafficker uses a direct message feature of a social media app to solicit a child, then they would be, if the child's on campus for a school activity or within 1,000 feet of the school, then the enhanced penalty would apply. But if I read this subparagraph 2, then the enhancement would not apply if the minor's presence on or within 1,000 feet of the school premises is not related to a school-sponsored activity.
No.
To me, that seems, to the point that's being made,
The gentleman yield?
Yes, sir, I'll yield for that.
That is correct.
That's a correct reading of the language.
Yes.
Okay, so I'll say now only in support of Mr. Fitzgerald's amendment, which is not precisely on the point I'm making, that I think the problem, and the more intensely I read the language and hear the debate, the more arbitrary the bill's enhancement seems to be. The bill's punishment.
Would the gentleman further yield?
Yes, I'd yield, Mr. Chairman.
The reason for that, let me just explain, is that we do not want the bill to cover children who have nothing to do with the school but happen to live, their house is within 1,000 feet of the school, but they have nothing to do with it.
Okay. So if some poor juvenile happens to live in that same place, let me just clarify that. So you say if somebody happens to live within 1,000 feet of the school, you don't want them to get this extra protection of the punishment enhancement. Well, but that wouldn't be the only thing because it doesn't rise or fall on whether the person resides within 1,000 feet. It's their presence there.
That is correct, because the intent of the bill is with respect to people who are interrupting kids getting an education.
So if a child comes to the school site for a church function or a community town hall, but not for a school-sponsored activity, and receives the message from the sex trafficker while there, we want to protect them less. We want to treat that as less severe in the law than if the activity going on is a school activity. Is that what I understand?
Yeah. You're talking about what a definition of a school-sponsored activity is, and if there were a debate or a sports event, it's a school-sponsored activity.
Yeah, but I'm not trying to have that debate with you, Mr. Chairman. Obviously, you could have a whole range, but surely you could use somebody could be on school, well, let's say they're on school property, they're in the softball field behind the school for the local sports league, nothing sponsored by the school, and the child's there. It's a trusted environment. I guess if that was the idea Ms. Jackson Lee's been offering as the reason for this, because it's a particular betrayal of trust for the child, then they're on that comfortable, familiar location for a safe place to have a community league sporting event, and they get sex trafficked. We're going to protect them less? I think that will just have to hang in the air as a rhetorical question. My time's expired. I yield back.
The time of the gentleman is in fact expired. For what purposes Ms. Jackson Lee seek recognition?
Strike the last word.
Gentlelady is recognized.
First of all, I want to thank my colleagues for this vigorous discussion. I want to thank particularly my colleagues on the Democratic side for seeing the rationale and reasoning of this legislation. So for clarity's sake, let me be very clear. There are many children who are unnamed in the United States who are victims of the scourge, the dastardly act, the viciousness, the violence of human trafficking, sex trafficking, many of whom are never seen again by their family. I want to acknowledge a young woman by the name of Felicia Johnson and her family, Mr. Johnson, who spent months in Houston trying to find his daughter that was lured away on some very unseemly conditions. But I want to also emphasize Courtney Litvak, who was here and willing to have her story told. These are the children who have had traumatic experiences in their life, possibly leaving them emotionally and physically susceptible, and they fall victim to human trafficking, which I said earlier is more profitable than drug trafficking. That does not mean that there is not merit for another time to deal with this whole litany of human smuggling and really making new provisions in this bill that seems to discount how vile human trafficking is associated with schools. We're at our best when we are focused, the bill passes, and it becomes law. Texas thought well of that concept. And I thought, with Mr. McCall and other co-sponsors, well of the concept for the nation, which is stop the human trafficking cycle in our schools. Children as young as elementary school children. And as I said, Courtney was a junior in high school, and she became vulnerable through friendship and support when she felt she had none, meanwhile drawing her gradually and deeper into the life. She was groomed by 2 different organized crime networks simultaneously, and each groomer chatted with her through social media and messaging apps. One network even invested in grooming Courtney for almost an entire year. She grew to trust these people who were in fact all friends of family, friends of friends, and all formerly attended her high school. Her first trafficker picked her up from her school on multiple occasions. As we sit here today, consequently, she was unenrolled from her school and had her entire life uprooted in a desperate attempt for her family to intervene in her exploitation. She returned back to her hometown, where days after turning 18, she was taken from her home by other invested trafficking network. We're trying to stop this kind of sheer attack on our children. That is a worthy action. This bill is worthy. And so we're trying to focus on the school zone, and it should be focused on, and that's why we have the enhancement. The idea that this bill is not expansive enough is foolery, tomfoolery. Because what it seeks to do is to end this crime of human trafficking and sex trafficking tied to our schools, and I can assure you there are millions of schools and millions of children that are vulnerable to this kind of life. I'd like my colleagues to support the underlying bill and to recognize that the gentleman's amendment is an expansion that takes us away from the crux of the reason that we're here, is to end this kind of devastating actions by many. They've got a full-time business. They've got cartels inside the United States on the human trafficking of our children. That is what I want to see ending. With that, I want to yield back and ask support of the underlying bill.
The gentlelady yields back. For what purposes Mr. McClintock seek recognition?
To speak to the amendment under the 5-minute rule.
The gentleman is recognized.
Mr. Chairman, this discussion is an exercise in absurdity. Let me give you the numbers. DHS expects that we will see 161,000 unaccompanied minors illegally cross our border this year. That's 441 arriving each day, many of them who have been abused along the way, and this doesn't begin to include the minors that are arriving in the company of adults. They are flown with U.S. taxpayer dollars all across the country. They arrive at their destinations deeply indebted to the cartels by many thousands of dollars each. There is no follow-up on their welfare once they're deposited by our government or its NGOs at their destinations. And then you're shocked, just shocked, that we have this epidemic of human trafficking. Where do you think they're coming from? They're coming because you open the borders, and these children are now being exploited to the enormous profit of the cartels and their affiliated gangs. You're only concerned about them if they're trafficked at school? This is an absurdity. So stop this virtue signaling about how much you care if you're not willing to address the underlying problem. And clearly you're not. I yield back.
Gentleman yields back. For what purpose does the gentleman from Texas seek recognition?
Speak to the amendment.
Gentleman is recognized.
I want to raise a couple of points. The first point builds a little bit on what the gentleman from North Carolina was talking about earlier, and others of my colleagues about the concern about the focus on schools only. I understand what the gentlelady is doing. Obviously, as a Texan, I know the legislation was passed in the legislature that focused on that. But, for example, if you look at finding 6 in the ANS, quote, while the internet and social media make up the majority of first encounters, traffickers regularly find young people in shopping malls, through friends, at bus stops, and at schools. Specifically, traffickers systematically target vulnerable children and youth by frequent locations, plural, where they congregate, including schools. I think given that we all share the objective of stopping human trafficking and respect the direction that the gentlelady from Texas is going with wanting to do that, I think the question being raised, at least on this side of the aisle at this point, is we seem to be doing this arbitrarily. I have an amendment in a minute that I will introduce that just seeks to just focus on enhancing the penalty generally without respect to it being at a school or not at a school. We'll address that separately, but I think that's part of the problem. And I think with the current amendment that we're addressing and that the gentleman from California just addressed about the nature of the problem we're dealing with, we're kind of dancing around it. Like, I understand the school focus, but there's myriad other locations where children are targeted, myriad other ways children are targeted, social media, et cetera. There'd be any number of ways we can enhance. We could have a 5-year enhancement for using social media to target a kid. You could have a 5-year enhancement for any other ways to target children. And what we're talking about with the gentleman from Arizona, what the amendment we're currently addressing, we're talking about the issue with the border traffic, which the gentleman from California very clearly articulated just a moment ago, lies at the heart of the current epidemic, the current problem. And that's the reality. The gentlelady from Texas is correct that this goes beyond the border trafficking and that there is a trafficking problem in our country irrespective of that. But it is order of magnitudes worse in our current environment with the amount of flow coming across the border, and all law enforcement will acknowledge that. And it just seems like we should be addressing that issue in totality and addressing the entirety of this complex problem to get at the heart of what the gentlelady from Texas suggests that she wants to do, which is address the problem, the scourge, as she said. And I share that desire. I am concerned about the focus on the schools only. It starts to raise federalism alarm bells in my head when we start going in and specifically targeting specific parts of a state and targeting schools. Not to say that I wouldn't support the measure, but I think we would do well to have a broader approach that deals with the true international and interstate nature of targeting of children that is particularly beneficial for Congress to focus on as opposed to a legislature. I would yield to the gentleman if he wants it on his amendment, or anyone else on our side. Mr. Biggs.
Thanks, Mr. Roy. I just want to raise 2 points related to the discussion we've had. I certainly, when I first read 2422 in preparation for this hearing, my bad, poor reading, I suppose, I think we should update that language so it's specific about the social media platforms, et cetera. The second thing is, I do think that if I understood the chairman in his colloquy with Mr. Bishop, this notion that if you're not at that school and in one of the school-sponsored activities, and you get trafficked, somehow your trafficker doesn't get that enhancement seems odd and peculiar, particularly in a state like Arizona where you have so many charter schools where people live within 1,000 feet of the school district. They may be on that traditional district, but they go to another school. This bill, I support the idea. I understand what they're trying to do, but you're not getting at the heart of it, as Mr. McClintock said, and there's some things in here that just really need to be straightened up and cleaned up if we're going to get this right and get after this and stop and deter people from trafficking our children, which is the idea behind this bill. Now, I'll get back to Mr. Roy.
Gentleman yields back. Is there any further discussion of this amendment? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, nay? No? No. The opinion of the chair, the noes have it. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
Come in.
What was that?
Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Escobar? Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Is Mr. Cicilline recorded?
I'm prepared to be recorded if I'm not, Mr. Chairman.
Mr. Cicilline, you're not recorded.
I vote no.
Mr. Cicilline votes no.
Mr. Chairman, we're ready to go ahead and call the votes?
Mr. Chairman,
Mr. Johnson of Georgia?
Mr. Chairman, I'd like to know how am I recorded on this vote?
Mr. Johnson, you're recorded as no.
Thank you.
Mr. Chairman, how am I recorded?
Mr. Cicilline, you're recorded as no.
Oh, that's what I thought. Thank you so much.
How is Bush recorded?
Ms. Bush, you were not recorded.
Bush votes no.
Ms. Bush votes no.
Mr. Chairman. Mr. Chairman. Mr. Chairman. Earth to
What
Mr.
purpose does
Chairman.
Ms. Garcia seek recognition?
How am I recorded?
Ms. Garcia recorded as no.
Thank you. I wish it would be recorded. No, thank you. Just confirming.
Mr. Chairman, may I make an inquiry?
Yes, you can make parliamentary inquiry.
I'm just wondering, since we're doing nothing, can we adjourn at this point?
No, we're in the middle of a vote. Okay. Clerk will report.
Mr. Chairman, there are 19 ayes and 19 noes.
The amendment then is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? For what purpose does the gentleman from Texas seek recognition?
The amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7566, offered by Mr. Roy of Texas, page 3, strike line 20 and all that follows. through
Without
the end of-
objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank the chairman. As we have discussed before, as was addressed by the gentleman from North Carolina, a few of my colleagues, myself, we have some concerns about the extent to which this is focused solely on schools. Mr. Bishop raised some of the attendant questions that are raised from that in terms of locations nearby, activities on the school grounds, but it's not a school-related function, et cetera. I've raised some of the other concerns I have with that narrow focus and what we're leaving out when it relates to the larger problem of human trafficking, which I think we all recognize is a major problem. And I just have to say, you know, when I was a prosecutor, dealt with enhancements, we used 924C quite a number of times with respect to gun crimes. And while, you know, I used it to the full force that I could where appropriate, it was sometimes, in my view, awkward and clunky when you were using the enhancement. I mean, sometimes the enhancement sort of swallowed the underlying prosecution. And, you know, I've thought and believe today that it is cleaner to have a very clear punishment and have it be across the board and not get into these specifics of you're going to get the arbitrary reality of having an enhancement for a school-related function, sex trafficking crime, but not a non-school-related function, sex trafficking crime, literally on the same property or literally in the same context. And so what I'm suggesting is that to address the larger issue, we just increase the penalty, and we do so across the board. So what I have offered as an amendment is to remove the focus on the school. And again, I realize that the gentlelady from Texas did so in good faith, mirroring the actions of the Texas legislature. And not sure I would have supported it in the Texas legislature either, as opposed to a broader application. But certainly when you're talking about federal engagement and federal involvement, it seems even more appropriate for us to be looking at the broader context of the crime and be treating or giving the power to prosecutors to be able to go after these bad actors across the board, and not with respect to a arbitrary definition, notwithstanding, again, I think the good faith effort to focus on the activity that does occur in and around schools. So this amendment would increase the punishment to not less than 15 years, up from the not less than 10 years, and then change for the different categories. It would raise it to from not less than 10 to not less than 15, because this applies in two different sections. I think that's a better way to go about this. Let's go after the bad actors, irrespective of where the targeting or the sex trafficking occurs, because a bad actor is a bad actor. A kid that is trafficked is a kid. And I don't think that the federal government in particular, or frankly any of our legislative bodies, should create an arbitrary scheme whereby a trafficker in one situation is treated differently than a trafficker in another situation where the facts are identical, with the exception of whether or not it's affiliated in this instance with a school-related activity. So I would just say let's keep this cleaner, simpler, and focus in on an across-the-board application of a penalty as opposed to focusing in on the school, and I would yield to the gentleman from North Carolina.
Thank you. I thank the gentleman. I just want to clarify. So do I understand that your amendment would add the 5-year enhanced punishment to all forms of trafficking? Is that not quite right?
It would remove the enhancement, and it would instead simply change the punishment and set the punishment at a 5-year increased minimum.
Okay. So
Across the
it
board.
punishes all traffickers everywhere 5 years more.
Correct.
Makes sense to me.
Again, it is offered in we have a lot of, engagement in this committee. This is offered in good faith with the belief that we're all trying to work to figure out how to stop this terrible crime in the United States. I would prefer that, particularly as a federal body, we focus on an across-the-board application. And I understand some of my friends may be reticent on mandatory minimum increases. I understand that as prosecutor, you want to have some flexibility, but we're talking about the worst of the worst here. We're talking about people who are trafficking children for sex into the sex trade. And I think it merits the the penalty increase that we're offering here in the amendment, and I would yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. As Mr. Jordan said in his opening statements, a 2018 survey reported that 55% of young sex trafficking survivors in Texas were in school when they were being trafficked, and 60% of trafficked adults say they were first groomed and solicited for trafficking on school campuses. And that's why we want to focus in this bill on school campuses. And by the way, with respect to what Mr. Bishop said before, if it takes place on a school campus, a softball field, no matter who sponsors it, it's under the supervision of the school. So it doesn't matter if it's it would be covered. Well, we believe it would be covered, and that's not the main point. I just wanted to make that aside. So that's why we want to focus on schools. In addition to which, the bill enhances maximum penalties across the board, and we don't mind that, that's fine. But it also enhances mandatory minimums, and that we oppose because, well, we don't like mandatory minimums in the first place, but mandatory minimums remove discretion from the judge. So if you want to say that the maximum penalty ought to be 55 years instead of 45 years, I have no problem with that. But increasing mandatory minimums, that I have a problem with. So for all those reasons, I urge opposition to the bill, and I yield back. Who else seeks recognition?
I do.
For what purpose does Mr. Bishop seek recognition?
To speak on the amendment.
Gentleman is recognized.
So I won't, for the moment, revisit, Mr. Chairman, your argument in great detail about what that language said about whether the event is school-sponsored or not, but I think the problem obtains, which is it seems like an extraordinarily arbitrary distinction. So what Mr. Roy has said is sex trafficking is an awful, abominable scourge. Let's punish it more severely. Let's just punish it more severely. That makes all the sense in the world to me. But punish it everywhere. I don't know a reason why we would be less concerned with the migrant who a smuggler has brought across the border and taken somewhere. They haven't ended up on a school property, but they're being induced into, forced into, coerced, tricked into sex trafficking. Why would we have lesser concern for that person than someone who happens to suffer the inception of this on a school campus? Especially if the presence on a school campus turns out to be either you get the enhancement or you don't, based on whether the activity being engaged in was school-sponsored. That just makes no sense. I think Mr. Roy's amendment is a great solution to it. But what it reminds me of is what happened in 1986 when Joe Biden and, not coincidentally perhaps, Jim Wright of Texas, two Democrats, sponsored the bill to impose a disparity in punishment for crack versus powder cocaine. And they reacted to something very much like what the sponsor has articulated here. You're seeing an increased incidence of crack cocaine arrests and events. So they introduced this disparity that didn't really make any sense to respond to maybe the yearnings of their heart to show that they were being responsive to this new sort of more frequent form of the same basic crime. And we all know what happened over time, that Democrats of today don't want any part of that. In fact, Joe Biden himself, if you remember on the campaign trail, he tried to say he got rid of the sentencing disparity, but he co-sponsored it in 1986. So here we are again with an entirely arbitrary distinction being made in the way a crime will be punished to deter certain events of that crime. But it's almost like obvious and in our face that you have to think about the people who are suffering as victims of the sex trafficking crime who don't happen to fall into this enhanced subject matter and ask why it makes sense to take care of them less, to have the criminal justice system respond to them less, to devote less resources in imprisonment for their malefactors than you do in this event. I mean, I get the headline, you know, you want to target sex trafficking in school zones. I get why it has a political appeal, but as we've demonstrated in the conversation over the course of time, it is utterly arbitrary. And an obvious fix for that, if we're on the same page, that you want to deter sex trafficking because it is horrible for the victims, then let's just increase the penalties. So I think the answer that Mr. Roy's come up with is great. Increase the penalties for all of it. Same amount of increase in the penalties, just do it more widespread. Anyway, Mr. Roy, I yield to you for
Yeah, I think it's important to note that, and the chairman says we should focus on the schools because, 60% or whatever the number of it happens there. Assuming that's true, though, that still means 40% is not happening there. We still have a situation where traffickers are preying on the most vulnerable, which often are kids who are not in school, who are outside of the school system, where there's at least systems in place to protect them. And what about the foster kid, who's homeschooled? And the reality here is we shouldn't have an arbitrary distinction for the plus up that is based on a geographic location or a system, as opposed to, normally you're going to have an enhancement that would apply kind of similarly across the board. It's a more heinous act or
If I could, you'll take back just as good. So if it's more heinous, and I think the thing we've detected and can avoid is, I keep hearing how the Democratic Party's changed, but just like they did that sentencing disparity back in 1986, it turned out to have all sorts of horrific effects on people. Let's not do that again. Let's give them an opportunity and make it equal across the board. I yield back.
The gentleman yields back. For what purpose? For what purpose is the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Let me, with all of the graciousness that I have, respect the perceived intent to do good by my colleagues on the other side of the aisle, and I respect that. We want to look human trafficking in the eye and go to the heart of a substantial amount of human trafficking, not in Texas, but across the nation. Schools are ripe for picking, whether it is through the devices of social media, whether it is vulnerable children who have fallen on hard times and then become solicited by their own friends. and friend upon friend, and then human trafficking cartels. If a child is smuggled in, a child may ultimately be in a school, a child may be looked at as a particular victim, and so your whole issue about smuggling is taken care of under this legislation with our main focus. When we write legislation in Congress, yes, there are amendments, but as you well know, there is an intent and a focus. And we do so in order to get the bill passed in the time and the climate and the configuration that we have. I want this bill to be on the president's desk. And so we have drawn a bipartisan approach in the House, and we look forward to working going forward. I think that we've hit the nail on the head, because when I speak to a young woman who's allowed us to use her name, Courtney, it really speaks to what happened to her, and she disappeared from her family for at least 2 years. God knows how she was able to get back. And those children that are still out of our sight, out of our hearing, out of their family's love, and they haven't come back yet. And they got in this way through schools, either online or playing softball or being at the school picnic or being on the school grounds or being, in essence, broken children because of traumatic experiences in their life. Apparently, we did it right, because we have letters from 25 organizations that quickly. Major city chiefs thinks that they have the right kind of tool through HR 7566 to do their job. And they are major leaders in policing. They specifically talk about it's especially troubling that these crimes sometimes occur at schools, which should be a safe haven for our children. They believe this bill will play an important part in addressing child sex trafficking by establishing additional penalties for offenders. We establish additional penalties. This allows the prosecutors to do their job. State Representative Ron Reynolds, who knew about the state bill, indicates that the importance of the language we have in targeting those online. The president of the NAACP, Bishop James Dixon, who sometimes receives these victims of child pornography or child sex trafficking or human trafficking. The Hope Over Hurt organization indicates that this is an important. Wendy Turner, the Break the Cycle, who believe that this is an important way of dealing with the kids who are ostracized by their peers and then wind up in the claws of these individuals. Jacqueline Arutu, president of No Trafficking Zone, is likewise someone who recognizes with a very long and extensive letter. And then beyond that, the Houston Area Women's Center, American Big Sister, Real Beauty, Real Women Team, Survivor Leader Beatrice Saylor, Abby Kamen, Council Member Jennifer Bagari, President of Emerge, Bishop Blake, but 25 other faith leaders believe that this is the right way to go. And the enforcement mechanism, 10 years plus the enhancement, is nothing to dismiss. It is an effective prosecution. It is an effective sentencing. And to my friend, your amendment deviates into other aspects. You go off into another direction, another trail. You add and take away the attention from what we're here for, is to fight human trafficking. So we give the discretion to judges, but we have a base sentence and then they go up. And they can go up to what we've given them. So I ask my colleagues to support this and the many, many supporters of this, including the major city chiefs. With that, I oppose the underlying amendment and support the bill. I yield back.
Gentlelady yields back for purposes. Mr. Buck, seek recognition.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I actually wanted to ask Mr. Roy a question about his amendment. First, I want to thank Mr. Roy for this common sense amendment that deals with the overall issue as opposed to trying to piecemeal this out. And I suspect we won't deal with the overall issue if we continue to piecemeal this out. But Mr. Roy, can you think of any circumstance in which an individual induces, coerces, controls a child and forces that child into the sex trade where that individual, that defendant, that criminal doesn't deserve 15 years in prison?
I appreciate the question from the gentleman. He is, too, a former prosecutor who prosecuted for a lot longer than I did, and I appreciate his recognition of that truth. I mean, as a father of two, as a former prosecutor, it defies all belief, all common sense, that you would say that someone who traffics a child in the sex industry actually puts a child into that environment for that child to be sexually abused, that individual should not have a minimum sentence of 15 years.
I don't think there is a prison, a hole underneath a prison deep enough to throw that individual in. I don't think that there is a punishment harsh enough to throw that individual in. And anyone who votes no on a common sense amendment like this seems to me to be saying that there are some circumstances where someone can traffic a child, forcing a child into a horrific, life-changing ordeal, and oftentimes risking their life. And a no vote on this amendment, to me, suggests that someone is weak on crime and someone is just not caring about common sense. But I'd like to go down the line.
Gentleman yield.
Would the gentleman yield?
Oh, absolutely.
Would the gentleman yield?
Sure. Well, let me...
I yield Mr. Roy from Texas.
So, with respect to that point on the mandatory minimum, it is often a criticism of mandatory minimums that we're taking out discretion from both the prosecutor and the judge. To that I say, exactly. As a body, there are times and moments when, as a body, you actually purposely take away that discretion. Because you are saying that there is a crime, the elements of which being met, after having been indicted, after having been charged with a crime, you're indicted, you're brought forward, you're put before a jury, you are found guilty for those elements of the crime. And in this case, that is putting a child into the hands of sexual predators. And we're saying that there should be a minimum for that. By the way, the statute already has a minimum. It already has a mandatory minimum, and we're saying let's elevate that minimum from 10 to 15 or from 15 to 20, depending on the circumstances under the statute. Does the gentleman agree?
I agree, and I reclaim my time, and I just want to reiterate that there are a number of purposes of sentencing, and the deterrent impact of sentencing is important. And I know for a fact that criminals take into account sentencing penalties when they make decisions about the quantity of drugs that they carry, about whether to carry a gun during the commission of a crime or not. And these criminals will make a decision, and based on your great amendment, these criminals will be deterred from engaging in this kind of conduct as a result of your willingness and your courage in offering an amendment like this. And it is so unfortunate that this will probably go down on a party line vote, and it will it just is terrible. I wish we had victims of sexual trafficking in front of us here to tell their stories and to listen to them and to talk and to learn from them about the horrific experiences, and then have someone say that a predator that controls a child in a sex trade deserves less than 15 years. Unimaginable to me that could happen, but I thank the gentleman for his amendment. I support it, and I yield back.
Gentleman yields back. Does anyone else seek recognition? For what purpose does the gentleman from Kentucky seek recognition?
I move to strike the last word.
Gentleman is recognized.
I appreciate the gentleman's amendment, the gentleman from Texas, and it seems to me there are two parts of the bill, one of which I can support and the other I have reservations about. The first part of his amendment, which I can support, is removing this arbitrary line that's 1,000 feet within a school to say that somebody who is forced into a sex trade 1,001 feet from a school deserves less justice than somebody who was within 1,000 feet of the school. Seems to me to be absurd to draw this line there. And that the 1,000-foot limit was arbitrarily pulled from actually gun control statutes. They just pulled that out of there as if it were appropriate for sex trafficking for some reason. It also seems absurd to me to tell a young woman who was forced into the sex trafficking trade in a shopping mall that you deserve less justice, that the perpetrator of your crime wasn't as bad as the perpetrator who was 999 feet from a school. This part of the gentleman's amendment I support completely. He's removing this arbitrary limit where we're saying that you deserve more justice if you were within a school zone, or you less justice if you were at a mall or at a family member's house or in your front yard. I don't think to the victim it really matters where they were when they were victimized in this way. And so I support that element of the gentleman's amendment. But I'm not going to be able to vote for it, and it's not going to be a party line vote because I cannot support a mandatory minimum. And I know we have differences on this, and the originator of the amendment is a prosecutor. I'm not even a lawyer. Thank you. Yes, that was a brag. But you know, I do believe that criminals take into account the punishment when they decide how and where to commit crimes. But so do juries and prosecutors when they decide whether they're going to, if they know there's a, for instance, I don't, you know, the gentleman could have suggested life in prison as a mandatory minimum. And if a jury knows that you're going to give somebody life in prison, if they're prosecuted for this, they may be less likely to vote to convict. And the prosecutor, knowing that this heightened, you know, level of punishment might make it harder to get the conviction, may choose to try and pursue some other criminal statute, which isn't even exactly appropriate. You know, maybe somebody has clearly violated this. So I think it's hard for us to sit here and say we can imagine every application of this statute in every venue with every perpetrator and every victim and every jury and every prosecutor and every judge. And so because of the mandatory minimum aspect of it, you know, I can't support it, but I do appreciate the amendment and the spirit in which it was offered.
Would gentlemen yield?
Absolutely.
Yeah, so in that spirit, and I hear you, and I know that those are some of the concerns and pauses with mandatory minimums, and I have not, I've thought about those a lot over the years as a prosecutor and as a citizen. What I would suggest is, and if we had time, I mean, this would be one of those where I wish we could shelve this and have a more thorough debate about what we could do as a group, as a whole, because I've got concerns about the arbitrary focus, to maybe come up with something where there's an enhancement that applies equally across the board, or another option in order to encourage prosecution of these crimes across the board, and to you know, find a way that would do that that isn't arbitrary. And I appreciate the gentleman's comments. I know they're taken you know, from a place of sincerity, and I yield back.
Thank you, and I yield back, balance my time.
Gentleman yields back. Does anyone else seek recognition? In which case, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No. The opinion of the chair, the noes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee. Ms. Jackson-Lee votes no. Mr. Cohen. Mr. Johnson of Georgia. Mr. Johnson of Georgia. Mr. Deutsch, Ms. Bass, Mr. Jeffries, Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu.
No.
Mr. Liu votes no. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Jayapal. Ms. Stimmings. Ms. Stimmings votes no. Mr. Correa.
Correa votes no.
Mr. Correa
Correa
votes
votes
no.
no.
Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath. Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean.
No.
Ms. Dean, you'll have to turn your camera on. Ms. Escobar.
No.
Ms. Escobar votes no. Mr. Jones.
No.
Mr. Jones votes no. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush.
Bush votes no.
Ms. Bush votes no. Mr. Jordan. Mr. Jordan votes yes. Mr. Shabbat. Mr. Shabbat votes aye. Mr. Gomert.
Aye.
Mr. Gomert votes aye. Mr. Isa.
Aye.
Mr. Isa votes aye. Mr. Buck. Mr. Buck votes aye. Mr. Gates. Mr. Gates votes aye. Mr. Johnston of Louisiana. Mr. Johnston of Louisiana votes aye. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Stubbe.
Yes.
Mr. Stubbe votes yes. Mr. Tiffany. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy.
Aye.
Mr. Roy votes aye. Mr. Bishop. Mr. Bishop votes aye. Ms. Fishbach. Ms. Fishbach votes aye. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Benz.
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens. Mr. Owens votes aye.
How is Swallow recorded?
Mr. Swallow, you were not recorded.
No.
Mr. Swallow votes no.
How is Jayapal recorded?
Ms. Dean, you were not recorded. Ms. Dean votes no.
How am I recorded?
How is
Bass?
Jayapal recorded?
Ms. Bass, you are not recorded.
No.
Ms. Bass votes no. Ms. Jayapal, you are not recorded.
Jayapal votes no.
Ms. Jayapal votes no.
Mr. Johnson of Georgia?
Johnson of Georgia, how did the chairman vote?
Chairman voted no.
Georgia, Mr.
Johnson votes no.
Mr. Johnson of Georgia votes no.
Are there any members who have not been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 16 ayes and 22 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? For our purposes, Mr. Johnson of Louisiana.
Reserve a point of order.
Mr. Chairman, have an amendment at the desk.
Clerk will report the amendment. Point of order has been reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7566, offered by Mr. Johnson of Louisiana. Strike minor, each place it
Without
appears.
objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I'll be brief. This one's very simple, and I can't imagine why anyone would not support it. I think this was an oversight, but this amendment would apply the increased penalties for human trafficking under the bill to adult students as well. The bill as currently drafted would only increase penalties for human trafficking at schools or within 1,000 feet of a school-sponsored activity if perpetrated against minors, but obviously not all students are minors. You've got special needs students who can stay in high school until they're 21. You have many seniors in high school that are 18 or 19. This bill would not protect these students in the same way it protects their classmates, and that doesn't make any sense. So the bill, in its findings, writes that, quote, no community, school, socioeconomic group, or student demographic is immune from human trafficking, and that's, of course, true. So why would we put an age limit on protecting students? It also finds in the bill that homeless youth, those in foster care, and other marginalized students are often the ones targeted by traffickers. Of course, that's true as well. These same groups of students are often held back a grade because of the challenges they have in life, which means many of them are no longer minors when they are still in school. So there's no reason we should limit the protection of students at school just because they're 18 or older. It's also worthy of note, I'll say before I yield back, that the Texas legislation that this bill is modeled after applies to both minors and adults who are trafficked at school. With that, I will yield back.
Ms. Jackson-Lee, do you insist on your point of order?
I withdraw my point of order.
Thank you very much. I recognize myself in response, and I thank the gentleman for bringing forward this issue. I think the chairman would recognize it is germane. However, it's not appropriate for the scope of what we are doing here. I completely agree with you. Students who are above their minority need protection as well. But for the scope of this, we have focused on minor children, those not yet attaining the age of 18. That would open up a whole other host of issues. And so I'm pretty sure this committee would like to work with you on that to make sure that students who are above their minority are also protected.
Would the gentlelady yield for a moment?
I will yield.
So the underlying statute applies to both adults and minors. I think Ms. Jackson-Lee's staff acknowledged that. So how does this open a Pandora's box? I'm not sure what the opposition is.
That's not entirely true.
GAO report, a CRS report, and a U.S. Sentencing Commission report that all say that this underlying statute, both sections A and B, apply to minors and adults. And because their bill specifically says students in schools, it would only apply to minors and adults who are students in schools.
Madam Chair, if I may, I would like to enter into the record reports from the GAO, the CRS, and the U.S. Sentencing Commission, who all acknowledge what I just said, that this also applies to adults and minors. The bill as it's drafted only applies to students who are under the age of 18, and so...
What you said, excuse me, what you said was true for Section 1591. Mm-hmm. That is not true for both sections under Section 2422. That's the distinction.
Well, I think...
So, as I said, we'd be happy to work with you on that, but for the scope of this legislation, we are not venturing into that.
But my offer was turned down, so I don't think they want to work with me. And Ms. Jackson-Lee's staff acknowledged what I said was true. So
I know this chairman, and I know this committee, and in good faith, I believe we will work with you. I yield back. Does anyone else seek recognition? For what reason does the gentleman? Mr. Biggs, are you seeking recognition?
Yes, I'm going to strike last word.
You are recognized for 5 minutes.
Thank you. I'm going to yield to my friend from Louisiana first.
Thank you. Mr. Biggs is an able clerk here, and he just showed me it's section 2422 of the statute is subtitled coercion and enticement, and it specifically says that the relevant language is coerces any individual who has not attained the age of 18 years. And then subsection A applies to adults. So I don't, what am I missing? I mean, this is a good faith colloquy. I'm trying to figure out why in the world.
Section A is the adults, as you just pointed out, and
Right.
Section B is the minor.
Okay.
We agree with you.
And the amendment would apply to the relevant section, right? That's how it's drafted.
We don't know how expansive
Yeah.
the scope would be if we added it to A, and so that's why we need to have further discussions with the advocates and state.
Subsection, yeah.
What the chair has relayed to me is we don't know if we relate it to Section A, how broad the scope of that will go.
So can I'm going to reclaim my time.
A or B.
I'm going to reclaim my time for a second while everybody regroups. Because the underlying bill, Section 4, refers to Section 2422, and specifically says in subsection B, by striking individual who has not attained the age of 18 years, and inserts minor. And I think that's what the gentleman's amendment is getting at, is bringing in adults to subsection B. Who,
That's what it does.
So you start, yeah, so basically striking subsection A and B, you're actually you're fixing it in both A and B. Anyway, I'm going to yield back to the gentleman from Louisiana.
Well, I would just say, I mean, as I said, the amendment is very clear. Page 5, line 5, strike subsection B and insert instead subsection A or B. So that bootstraps it together and makes it relevant. It does not open a Pandora's box. I can't imagine what we would need to study on this. We're trying to, I mean, the objective of the legislation is to protect children. Even if they're above 18, they deserve the same level of protection. And by the way, it's the most vulnerable subgroups of kids that the bill itself acknowledges. Why would we not do that? I don't understand. Yield back.
Thank you. I'm going to yield to the gentleman from North Carolina, Mr. Bishop.
Just a quick observation, the way this seems to be going, it adds yet another highly arbitrary discrimination in how the bill would change the statute to operate, introducing a sentencing disparity that has no basis in reason. It's just arbitrary. So we got the arbitrariness with respect to whether the person happens to be on school premises or within 1,000 feet because of a school-sponsored activity or not. The very fact that whether they're on campus or off campus doesn't make any difference to how much they suffer. Now you're talking about someone who could be a student involved in a school-sponsored activity who doesn't happen to be under the age of 18. They've had an extra year to graduate, but there was trafficked at that point, and there's no protection for that person, even though they're trafficked on a school campus. It's almost like you can't even imagine the amount of arbitrariness packed into this one bill. I think we ought to punish people more severely for trafficking. I'll probably actually even vote for the bill, but I mean, my goodness, why turn aside these opportunities to make the impact more logical? I yield back to Mr. Biggs.
And I'll yield to the gentleman from Louisiana.
I just want to point out, this amendment would be included in a portion of the code that applies to both adults and children that have been coerced into prostitution. The purpose of a markup is that we can improve legislation. This is not like an ambush thing. This is in good faith. I'm trying to improve the bill, and I don't know why we would preclude these students. I just don't get it. So I yield back.
I'll yield back.
Can you get your email, please? Strike the last word.
For what reason does Ms. Jackson-Lee seek recognition?
Strike the
You are
last.
recognized for 5 minutes.
Again, let me speak to the passion in which Ms. Johnson from Louisiana seems to be offering his amendment. And just for the record, let me be very clear to my colleagues on the Republican and Democratic side. My staff spoke directly to Mr. Johnson's staff and indicated that the advocates for the legislation are truly focused. I think after 2 decades plus on this committee, I know what a markup is. But I also know that we are here sometimes in focusing on, as Mr. Roy repeated me, the scourge, the scavengers who are out there that are going after our children. That is not to dismiss the question of those who are on college campuses. Specific language to your staff said, we are happy to work with you with this going to the floor, but not now. We don't have time to agree and need to run our traps. We need to investigate and fully understand the implications and make sure that we're not doing something that may harm the direct purpose of this bill, which I believe should be signed by the president, because it will save the lives of millions of children. Some, I keep repeating, and I'm going to get that data before we get to the floor, who have not yet been reunited with their families. They are still in the cycle of sex trafficking. Now, let me also say that the underlying statutes in this bill apply criminal penalties to conduct targeting minors in general and adults. We've got them in there where there are allegations of force, fraud, or coercion. So we're not totally blindsided or, in fact, not perceiving the danger at some point there. But I must respond in defense of all of my colleagues. The typical line of messaging. Mr. Jordan, we've quoted you. Thank you for your remarks. I know that you've spoken about the border and smuggling, but you did say that in our state of Texas, 55% are taken in human trafficking and sex trafficking from schools. When we do our landscape of the nation, as we go to the floor, we will find those numbers are somewhat comparable. Mr. McCall and myself, having dealt with this issue for a very long time, recognized way long time ago that Houston, because of its proximity and its big city, was an epicenter, but that does not preclude cities around the nation. I saw my first trafficked person sitting on the ground in Bangladesh with the late Secretary Albright. Girls who had been sold, trafficked, and they were finally being retrieved. It certainly was not in the United States, but it indicated we have a worldwide problem. So I'm not going to take a back seat that this bill is not a strong and vigorous bill that is going to go after what our targeted community is, saving the lives of these children as young as toddlers. And since I encourage those who are interested in this legislation to watch our debate, let me recount what they've said. They had to step away because one of them was the victim that I talked about. And they were frankly hurt that their story was so frivolously being handled. Their broken life, they're being snatched away from the school. They're being taken by a friend of a friend. They're being removed from their family, from that life, for years at a time until they had been rescued and retrieved. And they're fixing their life as we speak. And then I just want to finally say in the quietest way that I can, there are a number of judges on here. I served as an associate municipal judge. In that, I signed a lot of PC, probable cause warrants, and had some arrest warrants, and had some trials, etc. Don't come at me about soft on crime. I will absolutely not accept that at all for my colleagues or anyone else. We are strong on justice. We're strong on transparency and fairness. And we'll fight the criminals who go against our children, elderly, and others. And by not wanting to implode legislation that has been worked on so carefully, that does not characterize us as soft on crime. And I will not accept that. I reject it in its fullest. I ask my colleagues to fairly respond to the victims of human trafficking who are children and pass this bill, the underlying bill, the NTZ bill, H.R. 7576. With that, I yield back.
The gentlelady yields back. Who seeks recognition? For what purpose does the gentleman from Ohio seek
Strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. So, and I'll yield to the gentleman from Louisiana in just a second, but I think we're making this too complicated. I appreciate the remarks of the gentlelady from Texas. I don't know that I disagree with what she said, but it didn't address the amendment that's in front of us. The amendment, my understanding is right, is pretty basic. The underlying statute on trafficking has two categories. It has minors and those who have reached the age of majority. And then we have a bill in front of us that says if trafficking takes place in a school or school-related activity or in a school-sponsored event or school zone, we're going to enhance the penalties for people who do something that terrible. And all the gentleman's amendment is saying for those kids, those adults who are still students at that campus who are defined under the bill, we want them included as well in this legislation. It really is that simple. And oh, by the way, it's consistent with the underlying statute. So this is, as he said, his very first sentence, I think, when he offered the amendment was, why in the world I don't know why anyone wouldn't accept this. So we should just do it. And as the gentleman from Louisiana said, let's just be a committee that for once works on something that makes sense and just puts it in the bill and makes a good bill, a better bill, and God bless America, right?
God bless America.
That's what we're trying to do. So I yield to the gentleman from Louisiana.
I thank the gentleman from Ohio, and to Ms. Jackson-Lee, I would say, look, I agree with everything he said, and that's kind of the point here. We are in agreement. I think there's a small bit of communication, maybe a communication gap with regard to what was said between our staffs. First of all, I mean, we didn't get notice of this markup until Friday after 6 p.m., so we might have been able to do more work together had we had some notice of it. But that being what it is, I have two separate amendments. One would add the college and university provision. I haven't brought that yet. That's later. What I'm talking about right now is on the high school campus, okay? And one of the compelling stories you told earlier was about a poor student, a junior, and the terrible thing that happened to her being trafficked in high school. A lot of high school students turn 18 during their junior year. Would you not have wanted that individual to be covered by this? Look, the most vulnerable students are the categories that I read: the homeless youth, those who come out of foster care, marginalized kids, special needs students. Many of them are above the age of 18 before they leave the high school campus. Why would we leave them out of their protection here? I mean, I take you at face value exactly what you said. It's a good faith, it's a good piece of legislation. We're doing a noble thing here. Let's protect everybody on the high school campus. Why would we segregate some subcategory because of some question we have about the underlying statute, which I don't even think is accurate? I really do not understand the opposition to this. I don't get it. If you don't want to extend it to college and university campuses, then vote against my next amendment. I don't understand that either. I don't know why we'd want to preclude them either. But this one is high school kids who just happen to be a day older than 18. I don't understand the opposition. I yield to back to the gentleman from Ohio.
Well, I thank the gentleman for his amendment. It's a good amendment. I don't know that
Would the
anything
gentleman
else
from
needs to
Ohio
be said.
yield?
Yeah, I'd be happy to yield to the gentleman from Texas.
Yeah, it already applies, first of all, to 18 USC 1591, the enhancement. The only problem is the underlying bill on online, the underlying statute limits the age. And what we tried to say, Mr. Johnson, is let us look at this before we go to the floor, because we have to look at the ramifications, because you're trying to amend, but the underlying bill, underlying statute that we have limits that age. And therefore, we are not doing that at this point. But as work is looked at, we are interested in doing this in good faith before this legislation quickly goes to the floor, which is what I hope it will do. But it does not preclude us from looking at this particular narrow amendment that you're now offering today.
Would you yield for just one more?
It's Mr. Jordan.
Oh, he's still got 15. So could we not just err on the side of caution? If we find out by the research that this doesn't work for some reason, pull it out on the floor that way. Why not have it leave here in the best possible form to offer the most protection? I believe that's your heart. I mean, I'm trying to help. I genuinely am trying to help. This is not some sort of gotcha provision. I just don't understand why we wouldn't err on the side of caution.
I don't have the time, but I think it's better to say we add on as opposed to take out. That's a more difficult, complex situation. I've given you my best offering of peace and graciousness, and I hope that you'll have the opportunity to accept it. But in any event, I yield back to the gentleman.
Yield back.
Gentleman yields back. Does anyone else want to speak on this amendment? In that case, the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no. No. The
Recorded
opinion of
vote.
the chair, the noes have it. A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
I couldn't tell it was
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
Mr. Correa?
Mr. Correa votes aye. Excuse me,
Howard
Correa
Swallow
votes
recorded?
no.
Mr. Correa
Correa
votes
votes
no.
no.
Mr. Swalwell?
No.
Mr. Swalwell votes no.
Mr. Liu?
No.
Mr. Liu votes no.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 16 ayes and 21 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? What purpose does Mr. Johnson of Louisiana seek recognition?
Mr. Chairman, I have another very simple amendment at the desk.
Reserving a right to-
Mr. Johnson's very simple amendment will be reported.
Is he offered an amendment? Reserve the right to object.
Amendment is reserved. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7566, offered by Mr. Johnson of Louisiana, page 4, line 5.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
I'll be brief, Mr. Chairman. Thank you. The bill states that the term school means, quote, public, parochial, or private school that provides elementary or secondary education, unquote. This amendment is very simple. It would extend the term school to include college campuses as well. And here's why. College students are, of course, a primary target of traffickers. They regularly exhibit the qualities found in the at-risk category for human trafficking, such as increased stress, sleep deprivation, newfound exposure to drugs and alcohol. All those things can be used to manipulate a student. Sinister as it is, there's a common tactic that's become famous now, infamous, where criminals use this approach. They go to students on college campuses and they invite them to a Bible study. The students later find out there is no Bible study, and instead they're being recruited into a trafficking enterprise. This bill states that traffickers systematically target locations where students congregate, and that's true. But college campuses are the perfect example of that, with their many cafeterias and gyms and libraries and club gatherings and quadrangles and the rest. And, listen, it's not always outsiders who are preying on students. There are stories in the news. There's a couple here. An assistant basketball coach at Colby Sawyer College was recently indicted by a grand jury for human trafficking. Another terrible case from Sarah Lawrence College. A student's own father was sex trafficking her classmates and friends. Many parents are already anxious about sending their children off to college and whether they'll be safe. And we could ease some of their fears by extending the human trafficking penalties under this bill to college campuses where there are more places and more opportunities to be trafficked than in primary and secondary schools. That's a simple amendment. Again, I don't know why we would oppose that, and I yield back.
The gentleman yields back. Does the gentlelady insist on her point of order?
I withdraw my point of order.
Point of order is withdrawn. Who seeks recognition? On the amendment.
So, yeah.
For what purpose does Ms. Jackson Lee seek recognition?
Strike the last word.
Gentlelady is recognized.
The amendment is not as artfully drawn as we might need to create, not to create some additional problems, Mr. Johnson, but if we can work going to the floor with Mr. Nadler's cooperation and our co-sponsor, I'm willing to accept this amendment, and thank you for your interest. This is different from the other amendments because it speaks directly to a narrow addition, which is the institutions of higher education. So I'm willing to accept the amendment, Mr. Chairman, with that. And this amendment, just to repeat for my colleagues, is to add the institution of higher learning and obviously within 1,000 feet as well. And we're willing to accept this amendment.
In that case, does anyone else want to speak on the amendment? In that case, all in favor, say aye.
Aye.
Aye. Opposed, no? I don't, the ayes have it. The amendment is agreed to. Are there any further amendments to the amendment in nature of a substitute? In that case, the question, are there any further amendments to the amendment in the nature of a substitute?
I'd like to speak on the bill, Mr. Chairman.
The gentleman is recognized.
Thank you. And I really hope ultimately to ask a question. It's been an interesting ride through this, because I still actually believe I'm probably going to vote for this bill, but I've been troubled by all the arbitrary kind of twists and turns. And now I'm concerned about one other thing. I'd just like maybe to pose a question to the gentlelady from Texas if I can. I'm just looking at the language and understanding what we're doing here. Okay. So we've kind of batted away all the changes. And so if one of these offenses occur within 1,000 feet on the premises of a school with a school-sponsored activity, then here's what the language says. It says, whoever does that shall, in addition to the punishment otherwise provided under this section, be imprisoned for not more than 5 years. So what does that do? I mean, as a matter of how much more time somebody gets, does that mean, it looks like if I read that literally, if you go back over to the original statute, already the person can be imprisoned not less than 10 years, so we have a mandatory minimum there, or for life. So from 10 to life is the prison sentence they can already get. If you're adding to that not more than 5 years, then does that mean they just get another day? I mean, they could just get another day in prison on whatever sentence is otherwise imposed within that range? Or if they're sentenced to life, they wouldn't give anything more because they're going to be dead, presumably. So what does it do, Ms. Jackson-Lee? What does it result in? Does it increase anybody's punishment, and by how much?
Well, as you well know, under the construct of this legislation, this turns to the discretion of the judge, but you can get 5 extra years.
A maximum of?
5 extra years.
So what's,
up to
5 extra years over what?
Pardon?
5 extra years in
Over
addition
10.
to what?
Over 10 in one instance and 15 in another instance.
The judge figures out the guideline. And then
And as I indicated, the judge figures out the guidelines, and I can assure you, without knowing a judge in particular, that the scourge of human trafficking is as abhorrent to civilians as it is to the court.
So
and the court will look at the circumstances, I believe, and will have a worthy sentence for that defendant upon that defendant being convicted with a conviction of guilt.
So at the outside limits, the maximum this could do is a judge who was otherwise going to assess a sentence of the mandatory minimum alone, 10 years, the judge could assess another 5 years. Could the judge assess an additional day?
Well, you know what, Mr. Bishop, let me be very clear. I am not on the bench at this time. I have been, and I can tell you that judges in the trial level are fact finders and listen to facts. I would not pretend to know whether a judge would render a day, but I would tell you that the idea of human trafficking is abhorrent, particularly with children, and we believe we've given the judge the latitude within the sentencing guidelines to, in essence, as necessary, throw the book at the person who is using children over and over again in sex trafficking or human trafficking. We believe that we have that ability to, they give the judge that ability to do that.
I guess I'm just trying to understand whether the bill could just be completely illusory. That is to say, if all it does is say some amount in addition to another amount which was within this enormous range that the judge could already set, what difference does it make? I mean, if you've got the ability to sentence them to life already, are you just engaging in the illusion of adding punishment, but it really doesn't do anything?
No, I don't think that's the case. I think the Sentencing Commission will determine how the enhancement will be applied after the guidelines are calculated, And I think that, as I indicated, that I have confidence in the court at the district trial level, that the facts before them and the defendant who is guilty, that the court will make the decision that renders the penalty to the defendant, and they will know that they have been sentenced, if you will, to a very strong sentence. They will know that. And the trial will have gotten, they may have pled, but they will be guilty of human trafficking of a child or guilty of enticing a child online and dealing with that child, if you will, in a manner that is ugly and untenable.
The time of the gentleman has expired. For what purpose does Mr. Roy seek recognition?
Move to strike last word.
Gentleman is recognized.
So just building on that conversation, and when I alluded to earlier the 924C application in the context of predominantly gun crimes, go back and remember, but that language reads, to the gentleman from North Carolina's point, it reads, be sentenced, it says, shall, in addition to the punishment provided for such crime of violence or drug trafficking crime, be sentenced to a term of imprisonment of not less than 5 years. And I think what the gentleman's getting at, like in other words, that makes sense because you're saying you get the default plus up of 5 years more. It's like saying, okay, this thing's bad. Now, we've all had debate here and disagreement on isolating on just the schools. And okay, let's put that aside because we've debated that ad nauseum. I still think it should apply more broadly, but okay. But if you're gonna just focus on the schools or whatever you're gonna choose as the reason to enhance, I think when the enhancement has some minimum teeth to it, it then at least has the minimum teeth.
Would the gentleman yield?
Yes, sir.
It's really very simple.
Okay, good.
You have a statute that says, what is it, 10 years, whatever it is.
Yeah, 10 to life.
10 to life.
Right.
So the minimum is 10, the maximum is life.
Right.
What this would do would say the minimum is 15, the maximum is life.
No, that's what my amendment did.
It says not more than 5 years.
Yes, it is.
It could be 10 years.
Would the gentleman yield?
Yeah, sure.
Okay. Let me be very clear. You are engaged in a debate on mandatory minimums. We're not engaging in that debate right now. These provisions would, in fact, there's some of them that are 15 at base.
No, but
And so 5 years up, that will enhance over 15. There's some of them 10 years at base, if you will, and it's up to 5 years, that'll be 15 years.
Sure, but if I reclaim my time, not out of, all I'm getting at, to add to the gentleman from North Carolina, is put aside my amendment from earlier that would have reset the minimum, mandatory minimum across the board. As the chairman just said, it would have gone from 10 to 15 or 15 to 20. What I'm suggesting here is the purpose of this legislation, to the best of my understanding, is to create an enhancement if you engage in this activity at a school or in a school zone. And in the language, it's up to 5 years, which to the point of the gentleman from North Carolina is illusory or potentially illusory. And as opposed to, for example, in my experience of using 924C, which set a plus up, an enhancement of at least 5 years. So there is a mandatory minimum on the plus up, I would agree, but that's not, I'm just saying that gives teeth to the enhancement. And so if we're trying to make a big message, does that make sense? Am I articulating?
Can I ask
I would yield to the gentleman from Kentucky.
if you're not, here's maybe a way to ask the question. If you're not adding 5 years to the minimum, what are you adding 5 years to? Because the maximum is already life.
That's another way of asking that question.
Does this change the range from 10 years to life to 10 years to life plus 5?
No.
Yes.
It could be technically, yes.
Right, or does it seem to, reclaiming my time, my
the gentleman would
concern is
yield.
the way it's drafted is that you would have a situation where the current punishment is 10 years to life, right? So
Plus 5.
And so in this case, the judge comes in, and let's say the sentencing guidelines, you end up at 12 and a half years. And so they come in with their 12 and a half years, and they come in, they've got their enhancement, but the enhancement is 0 to 5. So you're basically just saying, well, the judge could have just marginally shifted the sentencing guidelines somewhere around 12 and a half. It's not really much of an enhancement, as opposed to in the 924C scenario, you actually have a boom. You come in with 924C and you get it, you got 5 years. Because I remember that because we used to prosecute the hell out of people using 924C. It was actually, frankly, the club was bigger than the underlying. But in any event, I would yield to the gentleman from North Carolina if he has anything else to add.
So with all due respect, the gentleman from Texas, I think you're pulling all the simplicity out of it that Mr. Massey just said. What we've been wrestling with and working for over 3 hours, given all the amendments that have been rejected, is a bill that takes a sentence of 10 years to life and makes it instead 10 years to life plus 5 years. That's all it does. Because it doesn't impose any, to the chairman's point, it would appear at first blush to read it to say, oh, you're adding 5 years to whatever sentence is otherwise going to be if you're in the school zone. That ain't what it says. It says up to, which means it could be none. And then the only sentence it could possibly affect at the end would be, it has to, is the life sentence, and get 5 years to that. What does that mean? I mean, it just is nonsensical. It's like we're trying to appear to be doing something and we're actually not.
I think it's inartfully drafted.
Gentleman's time has expired. If no one else seeks recognition, the question occurs on the, for what purpose does the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you so much. It seems to me that it's just the semantics here that we're dealing with over and over again. And I think we have to be mindful that we are not diluting the initial intent of this legislation. And with that, I'd like to make sure that my colleague from Texas, Representative Sheila Jackson-Lee, if she has anything else she'd like to speak about, I am more than willing to give my time to her.
I thank you. Again, let me remind my colleagues that the families of the victims themselves, the children that are still in the grasp of the cowardly hands of child traffickers, human traffickers, sex traffickers, do not think that this bill will not be effective, as it was in a state that happens to be very large, largest state in the union. And this begs the question, I know we've had some trials and tribulations with the courts. I certainly have that as well. But I don't in any way dismiss the court's discretion to see a convicted child trafficker, sex trafficker, human trafficker, and take advantage of the sentencing construct, which is 5 years, up to 5 years. That means they can hit them with 5 years. It's not inartfully drawn. It is consistent with other statutes. It's consistent with the sentencing guidelines. It is not an unworthy. It is very worthy. And I think the major chiefs have made it very clear. This will be an important tool for their arrest. Faith leaders, NAACP, and others. And we have now expanded it to institutions of higher learning, and the judge can render the decision, which will be a penalty that the convicted person will feel. And it is consistent with other guidelines, sentencing guidelines, and statutes that have worked very effectively. And what we want to do is to do something that has not been done, to focus on school zones in this nation. And I can tell you, this will be a wake-up call. I'm pleased to support it. I thank my colleagues for supporting it, and I ask them to support the NTZ zones, the NTZ legislation, which is 7566, No Trafficking Zones Act. And with that, I yield back to the gentlelady.
I yield the balance of my time.
Gentlelady yields back. For what purpose does Mr. Biggs seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you. I first have to just make sure everyone understands. We agree that human trafficking, sex trafficking is pernicious. We agree that we should do something more, perhaps. In fact, that's why we've tried to expand the scope of the influence of this legislation and assure that the language will work. Because you know what? It isn't just semantics. Courts are going to rely on this. Prosecutors are going to rely on it. And even counsel for defense is going to rely on it. And even, believe it or not, human traffickers that are considering there are ramifications. They will consider it, because one of the reasons you do criminal justice is to deter bad actors from repeating or committing crimes. So it's not just semantics. It's important that we get the language right. We support the underlying bill. We support the idea behind the underlying bill. We just want it to be right. In fact, not only do I want it to be right, I wish we were expanding it the way so many of us have urged today. It's unfortunate we didn't get there, but okay, I get it. But can we just do it so it's right? I'll yield to the gentleman from Colorado, Mr. Buck.
I disagree with my good friend from Arizona. I think this is clear as mud. If you are 17 years old and you are within 1,000 feet of a school, this applies. If you're within 1,001 feet of the school, it does not apply. If you're 18 years old and 1,000 feet of a school, it does not apply. And if you're 1,001 feet, it does not apply. It is not a mandatory minimum, but it is enhancing a 10-year mandatory up to 15 years if you're within that 1,000 feet of a school. So I don't see what the problem is with this. It's very clear. It's very, it's obviously well drafted, as the gentlelady from Texas said. And I can't see as a prosecutor anyone having any confusion trying to enforce this statute in the way. And I would love to see anybody argue in front of the Supreme Court what the legislative intent is of this statute, because we can't even agree on what the underlying sentencing would be, much less what the intent is. I think we know what the intent generally is, and that is to do everything we can to stop human trafficking. This bill fails miserably.
Thank you. And don't forget that if you're 18 years old on a college campus, you'll be protected. But if you're 18 years old on a high school campus, you're not going to be protected. So with that, I'm going to yield to the gentleman from Louisiana.
I was just going to point out that discrepancy. So, and really, this is not humorous at all. We're not having fun with this because the stakes are so high for the victims. And truly, for that last point now, if we amend, which I'm glad that we're going to have a friendly amendment and we're going to add college and university campuses, but there is the gap now. And seriously, just to point out the absurdity of this, for special needs students who are above the age of 18, by way of example, if they're on a high school campus, they're not protected. But if they somehow can transfer to the junior college, they are. So it makes no sense. And I just don't understand.
Gentleman yield, please. The gentleman yield. The gentleman yield.
It's my time. I'll yield to Mr. Bishop, then I'll yield to you.
Thank you.
I'll try to save some time just by adding to the complexity. And I agree. The only thing, from time to time, I've chuckled as we've done this because it's maddening. But at the end of the day, it appears possible to me that the bill appears to be toughening penalties, at least for some sex trafficking. But if you really look at it carefully, I don't think it even does that. It is possibly only appears to be doing something, and sometimes to appear to do something, to be trying to toughen penalties and actually do nothing, may be worse than to do nothing at all. Nonetheless, I feel like you've really challenged me to see what I can put up with, but I'm probably going to vote for the bill anyway, because I do not want to be understood as failing to be in favor of toughening penalties on sex traffickers. But man, this one is about as big a stinker as we could do it with. I yield
to the gentlelady from Texas.
I thank the gentleman from Arizona and want to relieve the pain of both Mr. Bishop and the pain of Mr. Johnson. Let you know that Mr. Johnson's example, they would be covered because they are on the school property. The underlying bill for online is different, but physically they would be covered. A disabled child, an 18-year-old child, they would be covered. And it is a bill with teeth. And I will yield back to the gentleman. I hope that I've relieved some of that.
The gentleman's time is expired.
A verbal attaboy.
Who? Somebody up there needs to mute your iPhone.
Darrell Issa.
Darrell Issa, okay. The gentleman's time is expired. Does anyone else seek recognition?
I have a UC, Mr. Chairman. I have a UC.
Gentlelady is recognized.
I am unanimous consent to introduce into the record, Mr. Chairman, proudly 25 letters for support of the HR 7566, the No Trafficking Zone, which includes major cities, Chiefs Association, religious organizations, NAACP, the Houston Area Women's Center, and a myriad of other letters that have argued the desperate need for this legislation and the need for it now. Ask unanimous consent to submit these
Without
letters into the
objection.
record.
The question occurs on the amendment nature of a substitute as amended. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. The opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 7566 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably.
Recorded.
The bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 6878, the Protecting the Health and Wellness of Babies and Pregnant Women Act of 2022, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 6878 to address the health needs of incarcerated women related to pregnancy and childbirth and for other
Without
purposes.
objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 6878, the Protecting the Health and Wellness of Babies and Pregnant Women in Custody Act of 2022, is bipartisan legislation that would help ensure that women receive the pregnancy, delivery, and postpartum care that they need while in federal custody. The number of women incarcerated has grown significantly in recent decades, and most women are incarcerated during their reproductive years. There are an estimated 58,000 admissions of pregnant women into jails and prisons every year. It is vital for the health of these women and their newborns that they have access to appropriate health care, nutrition, and postpartum recovery support. In addition, research shows that black women already have a 43% higher risk of miscarriage than white women. Since women of color are disproportionately impacted by the criminal justice system, a lack of support and care for pregnancy and reproductive health while incarcerated. Someone needs to mute their microphone. Research shows that black women already have a 43% higher risk of miscarriage than white women. Since women of color are disproportionately impacted by the criminal justice system, a lack of support and care for pregnancy and reproductive health while incarcerated can lead to increased risk of negative pregnancy outcomes. By establishing a national standard of care for incarcerated pregnant women, as well as prohibiting the use of restrictive housing and providing for transfers to residential reentry centers for women with high-risk pregnancies, this bill will help protect the health and safety of pregnant women and their newborns. Restrictive housing and solitary confinement have been called psychological torture, and the use of solitary confinement can further damage the physical and mental well-being of pregnant women. In addition to setting a national standard of care, this bill also requires the Government Accountability Office to study the services and protections provided to pregnant women incarcerated at the state and local level. The impact of incarceration on pregnant women is complex and far-reaching. The reality of pregnancy, delivery, and postpartum recovery while incarcerated requires significant mental and physical health care interventions and broader protections in order to address the trauma both mothers and newborns experience. This bipartisan bill is supported by a broad range of organizations across the ideological spectrum, including the American Psychological Association, the National Alliance on Mental Illness, the Association of Maternal and Child Health Programs, Dream Corps, the Vera Institute for Justice, R Street Institute, and the American Conservative Union. I thank our colleague, Representative Karen Bass, for her leadership on this issue, as well as her bipartisan co-sponsors for introducing this important legislation, and to urge all my colleagues to support the bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. An estimated 58,000 pregnant women pass through U.S. prisons and jails annually. This legislation builds on existing programs at the Bureau of Prisons to provide certain health and wellness-related services for pregnant incarcerated women. The bill also expands a Bureau of Justice statistics report to include statistics on the health needs of pregnant incarcerated women. It also requires the Director of National Institutes of Correction to provide education and technical assistance to state and local correction facilities in order to educate their employees about the consequences associated with restrictive housing and the use of restraints on incarcerated women during pregnancy, labor, and postpartum recovery. Provisions of the First Step Act, championed and signed into law by President Trump, changed the law to ensure that restraints are not used on pregnant women in custody of the Federal Bureau of Prisons or the U.S. Marshals Services. Mr. Chairman, I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 6878, offered by Mr. Nadler. Strike all that
Without
follows.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes several changes to the underlying bill. First, it removes the grant program for state and local correction systems. Second, it clarifies that the prohibition on restrictive housing does not conflict with a similar prohibition in the First Step Act. Third, it removes a GAO study, which was duplicative of a study already completed last year. The amendment also makes several other minor technical and conforming changes. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does the gentlelady from California seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
A few weeks ago, I had the opportunity to visit the women incarcerated at Victorville, California federal prison. I was joined by my colleagues, Representative Speer, Chu, and Obelnotre, and I'll never forget what these women shared with us. One woman was so painfully clear in expressing her sadness and frustration. She said the men in the institution that was right next door fight so they get attention. The women don't fight, so too often the needs and experiences of women are overlooked or undervalued. While they make up a smaller fraction of the prison population than their male counterparts, since the 1980s there has been an exponential increase in women in custody, at times growing at nearly twice the rate of the male prison population. Women are often held for nonviolent, low-level drug offenses, and their pathways to incarceration are often different. Common factors that contribute to criminal behavior among women include experiences of domestic violence, mental health challenges, and poverty. Unfortunately, they are entering a male-centered penal system not designed to meet their physical or mental health needs. Despite the fact that there should be a right to adequate medical care guaranteed by the Constitution, but also just basic decency, there are currently no federal standards to ensure that pregnant women receive the care they need, and that includes basic prenatal care, nutrition, etc. This also includes those who are essentially children themselves, because girls in the juvenile system can also wind up incarcerated and pregnant. Pregnancy rates among confined youth are actually similar to the rates of incarcerated adults. This lack of adequate maternal care has real tangible consequences. Some women and girls who become pregnant through rape, studies show that pregnant women in custody have higher rates of poor prenatal outcomes, to include miscarriage, preterm infants, and infants born small for their gestational age. When I visited the institution in Dublin, it was so shocking to hear that the warden of the prison and the prison chaplain had been arrested for rape. As a matter of fact, the prison warden had been photographing the women, bringing them into his office, photographing them and raping them. And you can only imagine that children born in custody have lower life expectancy and higher rates of socio-emotional challenges later in life. In particular, extreme methods of restraint and confinement are not only unhealthy in pregnancy, but can also be actively harmful. Placement of pregnant women in solitary confinement creates a serious risk of mental and physical harm and results in deprivation of critical nutritional and medical care. The use of restraints, which was prohibited by First Step, but we do need to continue to pay attention to make sure that restraints such as shackling that can lead to falls, increased pain during labor, and bone separation and muscle tears. I've worked alongside my colleagues to address these challenges for years, and the stories shared with me by impacted women are nothing short of heartbreaking. Every once in a while, a child is born that does not necessarily improve. The care does not necessarily improve, and this is despite the continued statements by the medical community regarding the importance of prenatal care, breastfeeding, as well as potential medical consequences for women who are unable to properly care for themselves. One of the other things that has happened to women in a number of cases, they have been confined in solitary confinement and have actually had to deliver their babies alone, where because they didn't have proper care, the staff was not equipped to understand that the woman was in labor, and the woman wound up delivering a baby alone, and in some cases, the children did not live. These practices are inhumane, they're barbaric, and they have to end. We can and must do better. I urge my colleagues to pass this bipartisan, vital legislation without delay. I yield back.
Gentlelady yields back. Who seeks recognition? For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to thank you for bringing this important piece of legislation to markup, and I particularly want to acknowledge the extraordinary leadership of my friend and colleague, Congresswoman Bass, for her tireless work on H.R. 6878, the Protecting the Health and Wellness of Babies and Pregnant Women in Custody Act of 2022. While Congress made important progress on this issue through the First Step Act, which because of Ms. Bass's leadership prohibited the use of restraints on pregnant women in Bureau of Prison Custody, more clearly needs to be done. Many incarcerated women do not have access to the prenatal care they need. Many are unjustly placed in restrictive housing, which can lead to unfair and unequal treatment just because the woman is pregnant. This is astonishingly still legal and widely used in Bureau of Prison facilities, a practice I suspect most Americans would find repulsive. By passing H.R. 6878, we will establish a much-needed and long overdue national standard of care to address pregnancy-related needs of incarcerated women, while also ending BOP's restrictive housing policies for pregnant women. These are important steps not only for the health of the mother and baby, but also for ensuring incarcerated people's dignity. Being incarcerated should not strip these expectant mothers of their humanity. I strongly support passage of this legislation. I thank Congresswoman Bass for her long and sustained effort in this space, and I yield back the balance of my time.
Gentleman yields back. For what purpose does Mr. Bishop seek recognition?
Strike the last word.
Gentleman is recognized.
I really have sort of a question on this restrictive housing issue. And so if I go over to, let's see, that's page 19 of the amendment in the nature of a substitute, it finally provides the definition of restrictive housing. It says, in this section, the term restrictive housing means any type of detention that involves, one, removal from the general inmate population, whether voluntary or involuntary. So if there's a pregnant woman and she wishes to be in some special room, area separated from other inmates, my understanding is this would preclude her from being able to make that choice. In other words, Bureau of Prisons could not accommodate that choice. Is that what am I reading that correctly? And why is that maybe to Ms. Bass, if she'd yield for a question, why is that what it says? It's what it appears to me to say, and why is that?
You know, it does not mean that if a woman chooses to be by herself that she can't, but we want to make sure that that woman actually has the care she needs. So for example, if there is a problem with mental illness or something, we want to make sure that she is supervised. And again, this is to prevent what has happened on a number of occasions, which women being isolated and then wind up getting into medical trouble and not being able to have the care that they need and then wind up delivering or getting into an emergency themselves.
And Ms. Bass, I'm not debating necessarily the issue of whether, I could see why if you don't want to be separated, you wouldn't be, but if she wants to be, I'm concerned about the term voluntary. Isn't that what the word voluntary means there? And isn't that a problem? In other words, if she wants to, if she's in her right mind and she wants to be separated in some separate facility, this would preclude the Bureau of Prisons from doing that, wouldn't it?
Key term is right mind.
Okay. All right. Well, I'm troubled by that because I think if the woman wishes to be separated and they have that facility available, I don't know why Congress should prohibit it. The second thing is, it means any type of detention. This next one restrictive housing definition also is any placement in a locked room or cell, whether alone or with another inmate. I thought in prisons they're kept, I thought that's the essential idea of prison is you're in a locked cell. No? Is that not right, Ms. Bass? Would you yield?
No, you're not. You can be in a locked cell, but not the whole time. You know what I mean? In other words, if you go to prisons, you will see that they might be in a locked cell in the evening, but during the day, the cells are open and there's areas where they congregate. And so the point of this is that we don't want the pregnant woman to be isolated, unsupervised, where she could get into trouble. That is the point, the intent of this.
Okay. All right, that was my main concern. I think in reading, I think I read the sections here conjunctively and I begin to understand.
There's an and, Mr. Bishop, right before the
Yeah.
number 3, and the inability to leave the room herself for the vast majority of the day.
Okay, thank you very much. I yield back.
The gentleman yields back. For what purposes Ms. Garcia seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, thank you for bringing this very important legislation forward, and I too want to thank Representative Bass for bringing it forward and having the time and attention and passion that she's had on this issue for many, many years. I'm proud to see that we're marking it up to protect women's life and health, especially marginalized women. This bill is a step in the right direction in providing some level of redress to many challenges women, primarily minorities, face when imprisoned within a penal system that does not focus on rehabilitation, but in fact dehumanizes them. This bill will bring dignity to women during one of their most significant life moments. In that spirit, I hope we extend the same consideration to immigrant pregnant women detained by ICE. Between 2016 to 2018, U.S. Immigration and Customs Enforcement detained pregnant women over 4,600 times. From January 2015 to July 2019, 58 pregnant women had miscarriages while in ICE custody. Immigrant pregnant women detained in ICE facilities are as deserving of this same dignity and humanity as those women who are in federal prison. Drawing distinctions to me is frankly unconscionable. In that spirit, Mr. Chairman, I urge the committee to consider H.R. 3993, the Stop Shackling and Detaining Pregnant Women Act. The nature and intent of H.R. 3993 are the same as the bill we are marking up today, treating pregnant women with decency, humanity, and dignity. I strongly support H.R. 6878, Ms. Bass's bill, the Protecting the Health and Wellness of Babies and Pregnant Women Act. But I do hope that we act on my bill, H.R. 3993. I hope my colleagues across the aisle will also support this legislation, and mine as well. They call themselves pro-life, after all. I would expect overwhelming Republican support for legislation that protects women during both their gestational period and postpartum. To call yourself pro-life and vote against this measure or my measure is the hypocrisy of the highest order in my judgment. Not supporting this legislation proves once again that Republicans are not pro-life, they are forced birth. With that, Mr. Chairman, I yield back the balance of my time unless Ms. Bass would like to use any of my remaining time.
Thank you.
The gentlelady yields back. Does anyone else seek recognition?
Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Move strike last word.
Gentleman is recognized.
Yeah, Mr. Chairman, I hadn't necessarily decided that I was going to talk on this bill at this point, but I think I'd like to now. I had intended to vote for this bill and still do. I don't think that the previous speaker's language was necessary. Those of us that are pro-life are very strongly supportive of both the rights of the mother and the child that she's carrying. And I would like to thank Ms. Bass and Ms. Lesko and Mr. Rushenthaler for their leadership on this legislation. I think it makes sense to do everything we possibly can to protect women, especially those that are pregnant. And I've worked with Ms. Bass on many different pieces of legislation, and commend her for offering this one. As Mr. Jordan mentioned, there's about 58,000 women a year that are incarcerated. So this is not something that is rare at all in this country. I think we have the second highest incarceration rate of women on the globe. I think only Thailand is higher. That's not necessarily something to be proud of, because we'd prefer that it isn't necessary to incarcerate so many people. But when people commit crimes, whether they're male or female, there's going to be a price to be paid, and generally these are repeat offenders, or a very severe type of crime that they've committed, or they wouldn't be incarcerated in the first place. But when they are incarcerated, it's our responsibility as a society to make sure that we're taking care of them and that they get the dignity and respect that they're owed. And so I commend this, the introduction of this legislation, and intend to support it. I think it's common sense, and for the most part, pretty well crafted. I think some of my colleagues, I think rightfully so, have focused some attention on some of these bills, many of which we did support, but I think it's healthy for us to, if there are weaknesses in these pieces of legislation, that we ought to make them better. And so I would encourage my colleagues on the other side of the aisle to actually either accept or take seriously some of the amendments that are offered, because I think many of them are offered in good faith and are just trying to make a bill better, or make it so that it'll actually stand up when it is challenged and ends up perhaps at the Supreme Court. That I know some of my colleagues on the other side of the aisle have a real problem with, because they tend to be a court that looks at the Constitution and takes it seriously and makes sure that the laws that we pass, many of which come out of this committee, are going to square up with that Constitution. But that being said, I again want to commend those that have spoken out in favor of this legislation. I do consider myself to be pro-life, always have been, always will be, and that means protecting both the mother and the child that she's carrying. And I yield back.
Gentleman yields back. For what purpose is the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Let me thank my colleague, Representative Bass, for introducing H.R. 6878, Pregnant Women in Custody Act of 2022. And I support this bipartisan common sense legislation because women serving time in federal and state custody matter. They deserve to receive proper health care and to be treated with dignity. The stories, Representative Bass, that you told of your visit in California was beyond atrocious. It was ugly, it was vicious, it was denigrating, and just to think of a warden engaging in basically sex trafficking of women inside the prison system that we had hoped had changed from the 16, 17, and 1800s of bondage and abuse and just throwing people away to restoration and rehabilitation. While women are the fastest growing segment of incarcerated population in the United States, discussions about criminal justice reform often overlook the unique experiences and needs of women and girls within the criminal justice system, and the issue of women's health is crucial, and that is usually overlooked. Because it's our responsibility to develop creative ways to address such issues, I'm glad the committee is considering this bill again. The United States is the second highest rate of incarcerated women in the world, with 64 women per 100,000 in custody. The number is growing, and most women are incarcerated during their reproductive years. In actuality, there are an estimated 58,000 admissions of pregnant women into jails, prisons every year. In my discussions with my colleagues on the other side of the aisle, I said that the women who are coming in pregnant. The GAO said there were at least 1,200 women pregnant in custody of U.S. Marshals Service and 524 pregnant in the Bureau of Prisons custody between 2017 and 2019. This bill would establish federal policies to prohibit the use of restrictive housing on incarcerated pregnant women and develop a national standard of care to address the pregnancy-related needs of incarcerated women, including access to prenatal and post-delivery care and support. Additionally, this bill would require BOP to collect data on the health care needs of pregnant women so that they and we may better understand the challenges incarcerated women face and determine how to address the needs of this vulnerable population. In Harris County, Texas, on average, there are approximately 1,000 women incarcerated in the county jail, and on average, 25 to 30 of them are pregnant. The jail offers specific programs for mothers to reduce recidivism and help them support their families upon release. HR 6878 would require jail to study state and local correction facilities to understand what are best practices. The study would ensure incarcerated pregnant women receive vital prenatal health care, postpartum support. Oftentimes, pregnant women lack access to appropriate nutrition, which is detrimental, restrictive housing, which is detrimental to the health of the baby. While women of color are disproportionately impacted by incarceration, they also face high risk of both miscarriage and maternal mortality. So this bill would ensure BOP and the Marshals Service protect the health and safety of incarcerated women throughout their pregnancy, and I'm glad to hear bipartisan support so they can recover during postpartum. Setting national standards for the treatment of incarcerated pregnant women in federal custody will set an example for state and local facilities to follow, and the data collected by BOP will further inform Congress of the additional health and safety needs of this vulnerable population. I do want to say, in my work with the BOP, it will be our challenge to ensure that the BOP does what this legislation says for it to do. For it has a very weak compliance with legislation passed by members of Congress, and they just don't get the job done. And so I'm hoping that we will do, Congressman Bass, our due diligence. This needs to be on the president's desk, needs to be signed, and we want, if signed into law, for it to be followed. As we endeavor to navigate a new landscape for reproductive freedom across the country, we must recognize that incarcerated women deserve rights. As many of you know, I introduced the Samara bill, and that is to ensure the after effect of the incarcerated woman giving birth and what happens to that birth mother and that child. We never forget women like Andrea Circle Bear, who entered federal custody while pregnant, contracted COVID-19 while in BOP's care, and later gave birth while on a ventilator and died without ever seeing her child. That is a failure of BOP. I hope this bill will contribute to the healthy life of mothers, pregnant mothers, and will support the health and safety of pregnant women in custody, will treat them with dignity and treat them with the kind of care that is necessary. I want to thank Representative Bass and the co-sponsors and urge my colleagues to support it, and I join as a co-sponsor in this bipartisan legislation. I yield back.
Gentlelady yields back. Who else seeks recognition? What purpose? Does Mr. Johnson seek recognition?
Got an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to HR 6878 offered by Mr. Johnson of Louisiana. Page 13, insert after line 21 the following. 7, abortion, A, prohibit.
Without objection, the reading of the amendment shall be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
To continue in the spirit of the simplicity of my amendments today, I can do this, I think, in 1 minute. This amendment would simply clarify and ensure that abortions cannot be provided to pregnant, incarcerated women. It defines abortion plainly as, quote, the use of any instrument, medicine, drug, or any other substance or device that intentionally kills an unborn child, unquote. Language does include, in the amendment, exceptions to preserve the life of the mother, remove a deceased unborn child, and to induce birth to preserve the life of the child. The bottom line is this: the amendment would remove any ambiguity or loose interpretation or the possibility thereof that could cause the Bureau of Prisons, the United States Marshals Service, or any healthcare professional in the provision of their services to run afoul of the Hyde Amendment. That, I yield back.
I recognize the gentleman yields back. I recognize myself in opposition. I don't think this.
Withdraw your point of order.
Oh, the point of order is withdrawn. I don't think this needs much debate. The position of the parties are well known. The Republican Party opposes abortions. The Democratic Party, by and large, supports the right of a woman to have her own bodily integrity and to have an abortion if she wants one. And therefore, we are opposed to the amendment. I don't know that any debate is needed because I don't know what to say other than that we're opposed. The Republicans will support it. There's no point having the entire abortion debate over again. That can last all year. And I yield back.
Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Well, I think the gentleman's amendment is a good amendment in that it in essence, protects Hyde Amendment language and says we're not going to have taxpayer dollars be used for this. That's all it really does. And for a long time, Democrats supported that, even though Democrats take the position you just articulated. That's not what's at stake here, and would be happy to yield to the sponsor of the amendment to further make that point.
Will the gentleman yield just for clarification?
Let me just say, and then I'll yield. It's in paragraph A of the amendment, it says specifically, the Bureau of Prisons may not perform an abortion or allow the performance of an abortion at a Bureau of Prisons facility. By definition, then, that involves taxpayer dollars. This is just to be consistent with Hyde, which has been, the law of the land here for
the gentleman yield?
Sure, Mr. Chairman.
We are opposed to the Hyde Amendment. There is a total disagreement. We are opposed to the Hyde Amendment. We think it should never have been passed, and it should be repealed.
I'm glad you're on record for that, taking the time back, but I hate to tell you that is the law. So we're just trying to make sure this is consistent with...
Our function is to change the law if we so desire.
Wow, I've never heard it so frankly admitted that you oppose the Hyde Amendment. That's really a big revelation here.
Will the gentleman yield?
Yes.
Well, just to be clear, what the gentleman is saying, the chairman of the Judiciary Committee is saying, that not only should abortions be allowed in this country, but we ought to take other people's tax dollars to perform those abortions. That's what we're talking about. There are a whole lot of people that look at it different ways, and the states, of course, as a result of the Roe decision recently in the U.S. Supreme Court, the states are going to make these decisions themselves. But the chairman is saying, take other people's tax dollars and perform abortions with them. That's what's being said here.
Well,
it's amazing.
I appreciate the gentleman's comments from Ohio, but frankly, it's worse than that. It's take the life of an unborn child all the way up until their birthday. Mm-hmm. And then some Democrats say, even after that, as evidenced by the former Democrat governor of Virginia, and now they're saying, and oh, by the way, we want taxpayer dollars to be used in that. That is the position. So that's why this Mr. Johnson's amendments, and I'd yield back to the gentleman.
Well, it turns out, all of that being true,
I hope you guys are enjoying this make-believe conversation among yourselves.
My time.
It's kind of
it's Mr. Jordan's time. Hold on.
It's like
hold
it's
on,
fantasy. Have a good time over there.
Come on, bring it into order. It turns out that this vote that we're about to take, folks, is hugely symbolic because it goes right to the heart of the matter. You just heard the chairman articulate what they're for. You just heard Mr. Jordan explain exactly what that means, and Mr. Shabbat, and I'm telling you that this vote is one that everybody in America ought to pay attention to. I yield back to the gentleman from Ohio.
Gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to say thank you for articulating what I think is the position of most people on this side of the aisle, and that is that women have the absolute right to make their own health care decisions, and a bunch of politicians in Washington ought not be making them for any women, regardless of their status, whether they're in prison or out of prison, period, the end. And finally, this claim, which Mr. Jordan just made, is repulsive and untrue. The notion that anyone is suggesting that abortion should happen up until the birthday is an absurdity and deeply offensive to women who are making important health care decisions every single day. And I yield the balance of my time to Ms. Bass.
Mr. Chairman, can we vote?
I would love for Mr. Cicilline to yield time for a question, if he would.
Mr. Cicilline, will you yield to Raskin?
I'm happy to yield to Mr. Raskin.
Thank you. Our colleagues represented this as a mini Hyde Amendment, but that's not what the amendment says, because it doesn't just prohibit prisons performing abortion. It also says prisons may not allow the performance of an abortion at a Bureau of Prisons facility. In other words, even if it were, imagine that an inmate is raped and impregnated by a guard, and then an outside medical provider said, we will provide the abortion. This would prevent the woman from choosing that, even if it's not paid for by the Bureau of Prisons. So this is not even within the four corners of the Hyde Amendment. This goes beyond that to say that essentially the woman can't get an abortion. So even in the case of rape, even in the case of incest, even in the case of the health of the mother, I think as I read it, she wouldn't be able to get it. So I'm happy to yield back to Mr. Cicilline, but this is not as it was represented. This is an effort essentially to completely nullify the reproductive freedom of basically the most powerless women in the country, women who are prisoners. I'm happy to yield. Thank you, Mr. Cicilline. I yield back.
Gentleman yield.
Yes.
I think the succinctness of the chairman, Chairman Nadler, answered it all. We are against the elimination of reproductive freedom, but I want to say to my friends over here, you have imploded the Supreme Court with judges who did not adhere to their confirmation hearings. You have states across America denying women reproductive rights. You have the state of Texas with the worst record on women's health and reproductive rights. And here we are trying to find a bipartisan pathway to deal with women's health in the prison by a very bipartisan bill. Why don't we move forward on this bill and leave the obviously divisive and truly no room for agreement question of the right of reproductive freedom to another time. First of all, the Hyde Amendment was restored. If we want to look at into the appropriations process, there are a lot of victories that you can claim. This bill has nothing to do with abortion. It has to do with the health care of the woman, incarcerated, pregnant woman, and you will not find agreement on your amendment, Mr. Johnson. At least, let me speak for myself, and I think the chairman has captured it accurately. We believe in reproductive freedom. You do not. Why don't we speak to the bill that the Congresswoman has and move forward on ensuring the good health of women who are incarcerated? The numbers are going up, and they have a desperate need for good health care, and particularly if they're pregnant. With that, I yield back to the gentleman.
I yield back.
Gentleman yields back. Does anyone else seek recognition?
No.
If not,
Can we vote?
what purpose does the gentleman from Texas seek recognition?
Gentleman from Louisiana, one at a time.
Well,
Will the gentleman yield?
wait, let me just,
Do you want to?
just for 10 seconds, I just want to say, if we're going to talk about healthcare policy and healthcare issues, to us and to, I think, a large number of Americans, the quintessential healthcare issue is the sanctity of every single human life, the sanctity of the life of the unborn child. And, you know, what we find in this debate is that many of our colleagues on the other side, many of the activists and advocates, and many of the, you know, expert witnesses that have been brought before this committee, they are unwilling to acknowledge the humanity of the unborn child. And all this policy skirmishes and everything aside, at the end of the day, that is ultimately the question that has to be answered. Is that a child or not? If that is a child in the womb, then it deserves the protection of law. It's pretty simple to us, and it goes right to the heart of who we are as a people.
So will the gentleman
Oh, wait a minute. I'm not
yield?
done. Hold on. I'm going to yield back to Mr. Roy in just a moment, but I just want to say this. The bill that your party advanced in this Congress does indeed allow abortion all the way up to the moment of birth, regardless of all the talking points and everything that everybody tries to dismiss. And it is barbaric, and it puts us on par with North Korea and China and a small handful of other nations in the world in terms of what type of abortion would be allowed. I don't think we're for that. I don't think the vast majority of the American people are for that. And I think a vote on a simple amendment like this highlights that as much as you all would like to obscure it. I yield back to Mr. Roy.
The fact that my colleagues and the chairman straight up just said the desire and the goal is to repeal Hyde, that you oppose Hyde, that is a significant public statement by the chairman of the Judiciary
will
Committee.
the gentleman yield?
I would also note, let me finish. I would also note that there was a flat-out rejection of the notion by the gentleman from Rhode Island of abortion up until birth,
Oh, Lord.
which legislation most certainly has been advanced by Democrats, and we have voted on such measures. We have born alive protection legislation that not a single Democrat has offered their signature to or co-sponsored or offered on the floor. And we've got the former Democratic governor of Virginia saying, quote, the infant would be delivered, the infant would be kept comfortable, the infant would be resuscitated if that's what the mother and the family desired. This is not fiction, as the gentleman from Rhode Island was alluding to, or fantasy, or whatever the gentleman said. This is real. That's why we're having this conversation. And the fact that the fairly straightforward amendment, which is what this was started about by the gentleman from Louisiana, saying this is straightforward, has turned into this, tells you exactly what is at stake in the amendment and raises the whole question of the underlying bill. I mean, it's actually central. That's what we're talking about. I don't know if the gentleman from North Carolina wants any time.
I do.
Will the gentleman,
Yield back.
Mr. Wade?
Gentleman yields back.
Can we
What purpose
vote?
does Ms. Ross seek recognition?
I move to strike the last word, Mr. Chairman.
And ladies recognized.
Mr. Chairman, I simply could not ever support this amendment, given the situation that women face in prison. As we heard from Mr. Raskin, this would not give a woman a right to an abortion if she was raped by a prison guard. Now, I don't know if the sponsor of the amendment knows how often that happens to women in prison, but it happens a lot. And to say that a woman would have the double indignity of having to be raped by somebody who is supposed to be protecting people and then have to carry that child is simply unacceptable. And this amendment further does not create any exception for the health of the woman. So she would have to get to be virtually on her deathbed before she would be able to choose to terminate a pregnancy. I cannot support this amendment. However, the underlying bill and its bipartisan nature are great for women's reproductive freedom and for their children. And I want to thank Ms. Bass and her co-sponsors, in particular, Mr. Reschenthaler, who I serve with on the Rules Committee, because as we know and we have heard, 58,000 pregnant women enter U.S. prisons and jails every year, and there are no federal standards for their care. Pregnant inmates frequently face inhumane treatment that puts them and their unborn children in danger. A 2018 study found that 82% of hospital nurses who worked with incarcerated pregnant patients said the patients were put in shackles some or all of the time. Last year, a woman in my state of North Carolina, Tracy Edwards, filed a lawsuit for the barbaric treatment she suffered while pregnant in a corrections facility. Any time she received medical care, Edwards was shackled. When she was in active labor, she was chained to her hospital bed for 12 hours. She was unable to move during labor, and this caused excruciating pain. She was also denied access to essential mental health medications and forced to go off her opioid addiction medication after giving birth. No one should go through that kind of abuse. Fortunately, in 2021, North Carolina passed a bipartisan law similar to this one, which limits the use of restraints on pregnant women and ensures that pregnant women and their babies receive quality prenatal, postnatal care, sufficient nutrition, and time to bond with each other. The North Carolina legislature passed the bill with support from groups on both the left and the right. That's how we should be approaching these situations. I urge this committee and this House to do the same. I urge support for the bill. I oppose the amendment, and I yield back.
Will the gentlelady yield?
Gentlelady yields back.
I do not yield.
Mr. Chairman, I move to strike the last word.
What purpose does the gentleman from Florida seek recognition?
I move to strike the last word.
And is recognized.
I want to thank the gentlelady from Texas for spending time with me yesterday to go over some of the provisions of the bill, and I left that discussion with the perspective that the bill was silent on the matter of abortion and really was about helping pregnant women in prison. But this debate has me quite confused, and particularly the last
Gentleman
speaker.
yield.
No,
The gentleman yield to
Mr. Chairman,
clarification.
Mr. Chairman, you weren't the one who created my confusion, so I'm gonna ask Ms. Ross a question if she would yield for a colloquy with me, because Ms. Ross said that this bill was great for reproductive freedom, and I would like to know how, if you'd be willing.
Mr. Gates, it's great for reproductive freedom because it respects when women want to have a child, that they get the care that they need and they are not abused.
In your mind, does it also respect their wish to not have a child?
It doesn't speak to that issue, but reproductive freedom also involves women who choose to have children and want to have those children under the best possible circumstance, free of abuse.
So it's not your contention then that the bill makes it easier for women in prison to have an abortion?
Mr. Gates.
Why don't you ask me? I'm not.
Mr. Gates, I think what you should do, if you want to address this to Ms. Bass, you can.
I'm here.
But women who want to have their babies need to be able to do it free of abuse and with support. And unfortunately, your party doesn't always want to give women who want to have those children that support. And I do not yield to any further questions from you at this time.
Pardon me, it's my time. And I'm asking questions of the person who created a great deal of confusion by saying that this matter was for the reproductive freedom of women. And I appreciate her yielding to a few questions that I think clarified that point. If the gentlelady would yield to another clarifying question, and I'm not here to make a partisan argument, I'm here to understand the effect of the bill and what you're talking about in support of the bill. You used the phrase unborn child in your most recent debate. What does that phrase mean to you?
Mr. Gates, Ms. Bass would like to answer your questions.
Well, then she can strike the
I
last
am
word.
finished with you right now, and I do not yield.
So that's telling, right? I mean, I'm just
guys
here trying to get answers to questions. You, Ms. Bass, you didn't use the words that were confusing, so I'm not going to yield to you.
And it is
I'm
my
not-
bill.
But you didn't use the words in description of it.
And
that were
guess
confusing.
why?
It was Ms. Ross who used those words. And if I
so
want to ask
what?
questions to Ms. Ross, she could choose whether or not to yield to give the answers. But you
But
covering for
you're
her,
not really
she
interested
doesn't
in
know
the
the words
answers.
she
You're
uses,
just
and
interested in
cannot
the
in the
theater.
Judiciary Committee sit and answer the questions
You
on something
answer
as
the
important as
question.
life or death when
Mr.
I
Gates
control
is-
the time is outrageous.
Are you done?
I'm
with
done
your
when my
theater?
time's done. And when
It's
I'm
Mr.
done,
Gates'
you can
time.
yield those. You can yield for those questions. But it's crazy that in this committee, when I'm trying to get honest answers to questions about the effect of the bill,
We don't want
whether or not it
honest
paves the way to abortions, that you all want to sit up there and squawk at me rather than allow me to ask questions. When you have the time, you can control the time. How about that? But these are fair questions. She used the phrase unborn child.
This is
I would like
theater.
to know what that means to her, because what it means
Then ask
to
her
us
on a break.
is that it is a life.
Time
But
is
you know what?
Mr.
I want the answer on the record, Miss Bass. I want the answer for the American people, because to all of us, my party that was impugned, we actually think that unborn life is a child, and that there is a liberty interest there that is worthy of our defense and our protection and the values that undergird the American Constitution. I don't think that's too unreasonable. And by the way, if you use a phrase in this committee, you shouldn't have to have a senior member answer the questions for you. You should be able to answer those questions yourself. And if not, I think it speaks to the credibility of the debate that is offered. So I'll yield, Ms. Bass. I got 50 seconds.
Thank you. I would like for us to vote on the amendment. I think the bill is clear. The rest of this discussion is theater. I would like to vote on the amendment.
Well,
Can we vote on the amendment, Mr. Chair?
I tell you what, Ms. Bass, reclaiming my time. We'll vote when we're damn well ready and when we're done answering our questions.
Oh, you chair the committee now?
No, we have rights in the minority to utilize time under the 5-minute rule to be able to offer our perspective on matters. And we're sorry if you all are in such a rush to kill unborn life that you're unwilling to answer our questions. But you know what? The good news is, with the Supreme Court we currently have, this is now a pro-life country, and we've got all the time in the world for that. I yield back.
Gentleman yields back. Who else seeks recognition? If no one else seeks recognition, the
Mr.
question
Chairman,
occurs.
move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I just want to say that I want to thank Ms. Bass for bringing in this excellent legislation. This has been a clarifying debate. Nobody has contradicted my reading of the amendment, which is that a female inmate could be raped by a guard repeatedly, impregnated by a guard, and she could not even pay for her own abortion or to get volunteers or donors to pay for her own abortion because she's in prison. And I think that that cuts against the views of the vast majority of the American people who don't accept it. And I'm perfectly willing to accept that this is the view of the author of the amendment, that life begins at conception and that women should have no choice in the matter in any case, including cases of rape and incest. I understand the intellectual consistency of that position. I think it's rejected by more than 80% of the American people. It is not the majority view of the American people who support, in general, a woman's right to make her own decisions about her health care and her family planning and her body and her life. But I understand the logic of that decision. But I think most Americans would be absolutely scandalized to hear that we'd be passing some amendment as part of a bill to help women in prison to say that if they are raped by a guard, they must carry that pregnancy to term, even if they don't want to, with every fiber of their being. So I'm going to oppose that amendment, and I'm going to support the underlying legislation.
Would the gentleman yield?
Yes, I will.
Thank you. I just want to clarify for Mr. Johnson. The bill does exactly what Mr. Raskin said, and it is silent on the question of abortion. Silent. The question of abortion is raised by Mr. Johnson's amendment. We are opposed to Mr. Johnson's amendment because we oppose the view that the amendment represents. But the bill itself is silent as to the question of abortion. I yield back to the gentleman.
Mrs. Ross doesn't think the bill is silent on the question. That's why Mr. Gates asked the questions of her that he did.
Excuse me, the time is my time, and I'm not yielding right now. So I want to say that Ms. Bass's bill is about actually supporting women who are in prison who are pregnant. And that's something I would hope that we would be able to get bipartisan support for. I'm glad that we have Republican colleagues who are supporting it. And I think that just as there may be parts of the pro-choice agenda that Republicans can support, I see that the governor of Virginia, for example, is backing a bill that would allow women to choose up to 15 or 16 weeks. That's not my position, but that's certainly not the position of those who declare that life begins at conception and that we should criminalize abortion nationally. I think there could be some parts of a pro-life agenda we could all support, which is that if women are pregnant, we should invest in their health. We should invest in the health of the pregnancy and of the child that they're going to give birth to. And that we should all invest in healthy children and healthy nutrition and healthy growth for kids. That's something that it should be an overlapping common ground agenda. So I salute the bipartisan group of members who've worked on this with Ms. Bass. I'm sorry that even on this, we have to allow kind of the ferocious debate over abortion spoil what is really has been a good debate about an excellent piece of legislation. But I for one, cannot support an amendment that would compel women raped in prison by their guards to carry that pregnancy to term. And I understand there's an honest difference of principle about that. And the people who think that a woman should not have a choice in that situation are honestly motivated. I think they are at odds with the views of the vast majority of the people. So I'm going to vote against the amendment. I'm going to vote for the bill, and I yield back.
The gentleman yields back. Are we prepared to vote on the amendment? The question occurs on the amendment. All in favor of the amendment, vote aye. Say aye. Opposed, no? No.
No.
The opinion of the chair, the noes have it.
Roll call.
Roll call is requested. Clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
Swalwell's no.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Ms. Steen?
No.
Ms. Steen votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert?
Gomer votes yes.
Mr. Gomert votes yes. Mr. Issa?
Yes.
Mr. Issa votes yes. Mr. Buck? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana?
Aye.
Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. McClintock? Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Fishbach votes aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes yes.
Mr. Correa? Mr. Correa? Mr. Correa?
Mr. Chairman, this is Stanton. How am I recorded?
You're not.
Mr. Stanton, you're not recorded.
I vote no.
Mr. Stanton votes no.
Mr. Fitzgerald?
There we go.
Mr. Fitzgerald votes
Mr. Chairman,
aye.
how am I recorded?
Mr. Biggs, you are not recorded.
Aye.
Mr. Biggs votes aye.
Are there any other members who wish to be recorded who have not been recorded? Clerk will report.
Mr. Chairman, there are 15 ayes and 22 noes.
The amendment is not agreed to. For what purpose does Mr. Jones seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
This term in Congress, the words and actions of my Republican colleagues have revealed the hypocrisy of their governing philosophy when it comes to protecting American children. On the one hand, they wax poetic about what they describe as the need to protect the lives of unborn children by limiting abortion access. At the same time, my Republican colleagues have relentlessly attacked Democratic proposals to expand paid family leave and pre-K education, along with my own legislative proposal to provide universal child care in this country. My Republican colleagues have also opposed any significant proposals to end the epidemic of gun violence in our nation's schools or stop climate change, despite the fact that the lives of millions of babies and other young people depend on it. These contradictions by my Republican colleagues prove that the only kind of child they care about is the kind that is, in fact, not yet living.
Today, this committee has taken up a bill to allocate funding towards the health of unborn children by allowing the pregnant women of America's prisons to receive the prenatal and postpartum care that they so desperately require. Today, this committee will vote to advance the Pregnant Women in Custody Act. Now, keep this in mind. My Democratic colleagues and I will never stop fighting until the fundamental right to an abortion, a right that Americans in all 50 states relied on for 50 years, is fully restored. The decision in Dobbs v. Jackson Women's Health has created a national nightmare in which millions of Americans have seen their bodily autonomy invaded by the far-right 6-3 majority on the Supreme Court of the United States. At this very moment, people are being forced to carry pregnancies to term in violation of their own free will and in violation of the very promise upon which America was founded. So much for the freedom my Republican colleagues like to talk about all the time. They don't care about freedom unless it's the freedom to discriminate against people based on how they look, who they love, or how they worship. They don't care about freedom unless it's the freedom to impose their broadly unpopular agenda on the American people. Because of Dobbs, women are being forced to seek out prenatal and postpartum care that they did not plan for. And they will do so in an unfair healthcare system that wrongly views reproductive healthcare as a privilege rather than a right. These problems create a perfect storm for pregnant people in America's prisons, places where basic healthcare, let alone prenatal healthcare, is lacking. The woefully deficient healthcare administered behind bars, when combined with the Dobbs decision, would be unimaginable in any civilized society were it not a fact of life as of a few weeks ago in this country. As we speak, incarcerated persons in states with draconian abortion laws are being forced to undergo the emotional and physical traumas of an unwanted pregnancy, all while lacking routine health care and, in many cases, the requirements of basic human living. Today, with this legislation, we have a clear chance to provide these individuals and their future children with life-saving support. I yield back, Mr. Chairman.
Gentleman yields back. Are there any further amendments to the amendment in the nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 6878 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed,
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.